Then matter for tomorrow, day after tomorrow. Earlier, we had moved this memo. The directed to be listed on 23rd. There was some delay in transmission of records from the affected bench. Writ petition, pollution control. There is a limited potential.
End of the list. End of the list. Hooliganism, willful disobedience of the order of the Honorable High Court itself, and Gundaism, everything is going on. All are cynics, retired cynics, and they are suffering from this. Kindly accommodate today. End of the list. Kindly. Because continuous process is going on. Continuously they are demolishing it.
Lordship, kindly, Lord, serial number 65, I may be permitted to withdraw from infrastructure. 65. My Lord, page 21, Lord, top. Please, my Lord.
Proceedings. There is one more for middle of this transcription.
My Lord,
Yes, sir.
contempt case, my Lord. Contempt case. Memo. My Lord, it's a contempt case, my Lord. Despite this Honorable Court passed an order for regularization of extending back wages, my Lord, the accused has not fulfilled the order, my Lord. All the complaints are senior citizens, my Lord. It may be taken up tomorrow or day after tomorrow. Yes, my Lord.
My Lord,
Serial number 122, my Lord. Kindly it may be taken up at 2:30. It is matter is settled, madam. We are going to file a compromise petition. 122. Parties will be present before this. 122, my Lord. No, 2:30 by 2:30. Please, parties will be present and it will settled. Compromise petition will be filed.
Lord, serial number 22, my lords.
Lordship,
Serial number 22, my lords. I'm for the respondent. I seek for a week's accommodation, my lord. I've informed the appellate. 22, my lords. I've informed the appellate. My lord. Commercial appeal.
serial number 25, my Lord.
There is no appeal.
Serial number 25, my Lord.
contempt pertaining to the ex-service man, the Lordship.
Look, serial number 39. I may request for a 2-week accommodation. I've informed the other side. 39.
Appearing for the accused here in Your Lordship, serial number 39. Your Lordship, if I may make one humble submission, Your Lordship, an affidavit was to be filed by the complainant based on the visitation which occurred on Friday. Your Lordship, if I may just point out one detail, Your Lordship, the fact that the father was threatening the child, Your Lordship, during this visitation. Moreover, he did not comply with the affidavit the passport that had to be given to the child. Only these 2 points, Your Lordship.
I will file.
Are you objecting to time?
No, Your Lordship.
Objecting to the request for time?
No, Your Lordship, I'm not objecting, but I just wanted to bring this to your Lord's attention. That's it.
Not objecting, then it will go to 12th of November.
Grateful, Your Lordship.
Serial number 54, my Lord.
25, my Lords. I request for a week's accommodation, my Lord. Inform the respondent counsel. 25, commercial appeal.
Commercial appeal.
Please, my Lord.
12th.
A week's accommodation, my Lord.
12th.
12, please, my Lord.
Lord, may I make a submission, my lord? 89 matter.
Yes.
89 matter, my lord. Office objections are to be clarified. My 3 weeks time I will kindly given, my lord. There are a number of office objections.
I appear for the appellant in that matter, my Lord. I have no objection to time.
89.
Yes.
So 4 weeks time
Please.
time for 4 weeks is granted to Remove all the office objections. 89.
Obligement.
Serial number 54, my lord.
Fix a date. Fix a date, your lordship, for 18.
No, unless you remove the office objection, then we'll,
The respondent has filed some applications which have defects. Appellant is complied with all office objections. In serial number 89, your lordship, the office objections are raised on some applications filed by the respondent. Appellant has complied with all defects in serial number 89.
learned counsel for the respondent, your respondent.
I am for the appellant.
The appellant stated that all the office objections are complied with. Registry shall verify the said aspect and thereafter place the appeal for admission hearing.
Your lordship, this is an education matter.
Yes,
I would like
Mr.
to-
My lords, serial number 95, my lords. It was listed for furnishing of PF, my lords. We have done the needful, my lord. Needful has been done, my lord, serial number 95.
What is done?
My lord, it's a contempt case, for 445 of 2024 for furnishing of PF, my lords. We have done the needful.
Needful, we also did do the needful. We don't know what is needful.
My lords, we have paid the requisite process fee and this thing.
So you complied the office objections. Learned counsel for the same order shall verify. Yes.
Your lordship, this is an education matter. I moved last week on the 21st and the court had granted me a date on 23rd, but the registry has not listed it, your lordship.
We don't.
I
there might be
request
some-
this matter may be listed tomorrow as the college is starting from next week and they have not made any accommodations in my matter, your lordship.
There might be some office objection.
Your lordship, this was listed before Justice Suraj Govindraj, who has directed the registry to not list this before him. That's why I request this matter be posted before the division bench.
No, it can't be. It will be
Because
placed-
this matter, similar matter is also pending before the Apex Court. I'm not able to mention the case number at the moment, your lordship, but
To ask the registrar judicial to put up the matter. We will see what can be done.
Please. Serial number 78.
78.
Request for 12, please, my lord.
Pardon?
May I request for 12, please, my lord?
Wealth,
Please.
12th.
Obliged.
My lord, serial number 114.
Oh, contempt is pertaining to ex-serviceman land, my lordship. Kindly may we have it in the next week, my lordship.
It will go to
Keep a matter.
3rd December.
Serial number 54, my lord. I pray for a short accommodation, my lord, today.
54.
Yes.
PIL,
Yes, ma'am.
what is it about?
My lord, it is about the construction in unauthorized construction, my lord.
Why you are seeking time?
My lord,
Why do you want time?
today I have some personal inconvenience.
Person can. 11th November.
My lord, serial number 114. My lord, I appear for the petitioner. My lord, office has raised an objection that the accused made party despite the not made party in the writ petition.
Serial number
Serial number 114, my lord. 114.
114.
114.
114.
14.
Yes.
So the office has raised an objection that the accused is made party despite the not made party in the pending writ petition before the single judge, my lord. The accused is the IO, my lord, I mean investigation officer who has filed a FIR. The FIR and the further investigation was stayed on the 10/11/2023, my lord, before the single judge. The charge sheet and the was put up before the trial court on 28/11/2023, my lord. My humble submission is office objection may be overruled, my lord. And if it pleases to my court, notice may be issued, my lord.
Office of the removed. Objections are removed.
May be overruled, my lord.
No, no.
Serial number 35, my lord.
Serial number 110, office objection has been complied.
Serial
Yes,
number?
further, serial number 110, your honor. Read up.
Serial number.
110,
What is 110?
no, 110, your honor, serial number.
What is 110? We don't know any 110. Yes. ma'am.
110.
Serial number
Then
35, my
tell
lord.
that 110. Your language will not work.
And for appellant, when this office objection has been complied,
Hmm.
however, they have raised further office objections.
Hmm.
Same will be complied.
Complied with.
Yeah,
Learned
2 weeks
states that the
later.
office will complied with. The registrar shall verify and then place the appeal for admission.
Serial number 50, I'm not
If
well.
the objections are complied.
Serial number 50, 550, I'm not well,
50. Yes.
not well.
What do you want?
Oh, I'm not well, my. I'm giddiness, I want.
Time.
I want time.
When?
Any day.
What is it about?
PL, false representation and misuse of the government sites. Making a false representation,
Hmm.
obtaining government sites, free sites,
Hmm.
and misuse.
So why you are seeking time?
I'm not well, my giddiness,
13th November.
much of.
My lord, serial number 35, my lord. Praying
30.
35. Praying time for file my objections to the main petition.
Yes, PIL
Yes,
22. What
Yes.
is it about?
ಇದು ಎಲೆಕ್ಷನ್ ಸಂಬಂಧಪಟ್ಟಂಗೆ my lord. ಎಲೆಕ್ಷನ್ ಸಂಬಂಧಪಟ್ಟಂಗೆ ತಪ್ಪು ಮಾಹಿತಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅನ್ನೋ ಕಾರಣಕ್ಕೆ. It's regarding to election.
So
Me-
what do you want?
I'm praying time, my lord.
Why?
Because we have received this petition in the month of 9th. So we have time to file our objection to the main petition. That is why, is the reason I am asking.
Let it be called out. When it is called out, we'll grant. We'll consider.
Your lordship,
To be here when it is taken up. Yes.
serial number 75, my lords. For the complainant, government has
Serial number?
75. For the complainant, government has filed the compliance affidavit. Kindly accommodate 2 weeks of time to file the reply affidavit.
Compliance, if it is filed, then what rejoinder is required in contempt proceeding?
Yes.
All right, 14th November.
Much obliged.
My lord, serial number 14 and 14.1, I'm appearing for the respondent in this matter. I seek time for 2 weeks. We require instructions from the client.
I have no objections, my lords.
14 and 14.1. 20th November,
Great for my lord.
20th.
Serial number 42, my lords.
42.
I appear for the respondent. I seek time for to file objection. To file reply.
So what do you want?
To file reply, 2 weeks time.
2 weeks time. 21st November.
Serial number 15, my lord.
15,
30th it we can release. 30th, day after tomorrow.
30th.
Other
One advocate, Mr. Kempe Gowda, wants the appeal to be kept on 30th October 2024. In view of his request, stand over to 30th October.
Any mention through VC?
Yes, any,
Fresh matters, contempt, serial number 1 to Shekhar L.
Lord, I am permitted to withdraw the contempt, my lord, since
Learned
the
advocate
management
Mr. Shekhar wants to withdraw
complied the direction.
contempt petition stating that the order is complied with, full stop in this regard. Memo dated 28/10/24 is filed, which is taken before dismissed as withdrawn.
Serial number 2. Rakesh Kini.
Here for complaint.
Order of learned single judge is page number 13, madam. Operative portion is at page number 15, madam. There was order passed by learned single judge to consider the representation at Annex H, madam.
Not considered.
That has not been considered. And to consider and the interim order dated 21/6/2022 also should be was protected, madam. As per the interim order, not to precipitate was the interim order granted, but they have seized my vehicle within 3 days.
15th November. Notice.
System number 3.
Lords, we have complied.
Complaint.
Please. Correction of.
Learned advocate Mr. Anita BG. Sorry, you are.
Renault D'Souza, Renault D'Souza, Renault D'Souza, advocate 2.
Renault D'Souza.
sorry, Renault D'Souza for the complainant states that the order under contempt is complied with. This was fortified by learned additional government advocate, Srimati Pramodini Kishan, in your above. The contempt petition does not survive. It is according to disposed of. Please.
This is number 4. Mati Archana came.
For the complainant, my lords. Let's the accused had filed GNWC, my lords, seeking for the visitation rights. The learned trial judge, my lords, partly allowed the application by annexure B, my lords. That was challenged by the complainant by annexure A, where for seeking for a modification of that order, my lords. And in that order, by annexure A at page 13, your lordships would kindly see that certain amounts the accused had to pay, my lords, regarding the children education expenses, my lords, none of which has been paid. The same school fee receipts were filed before the trial judge also, my lords, on 24/8/2024. My lords, he's constantly been absent in the trial court and is evading payment in all aspects, my lords.
So no payment is made.
No payment, absolutely. That apart 20,000 also, nothing has been paid, my lords.
Notice returnable on 8th November.
Obliged.
This is number 5.
Yeah, for the petition complainant in the matter. At page 23 is a direction issued by this honorable court. Page 23 is the order, your lordships, of this honorable court, directing to consider my application and issue Form C license, your lordships. Till today, except Form B, Form C is not being granted, your lordships. Within 2 months, this order had to be complied with. The order is dated 7 September 2023. Till today, the respondents have not complied with the order, your lordships. Page 23, para 4, your lordships. We further direct the concerned competent authority to consider the application made by the petitioner to grant Form C license afresh in the light of the so-and-so and take appropriate decision within period of 2 months from the date of the copy of the order.
Where is within 3 months?
Lordships,
Where the time limit?
para 4, your lordships. Para 4, last the third line, within a period of 2 months from the date a copy of the
Notice,
order.
notice returnable on 20th November.
Number 6. Mr. A. Nagarajappa.
For complainant, lordship, you are sought for modification of the village name in the survey number, lordship, and in regarding that order has been passed, lordship, but the same is disobeyed by the
20th November. Notice.
Number 7. Mr. Jagdish J.R. Number 7. This is number 8.
So I appear for the petitioner, my lord, the late matter, my lord had directed that we could file our objections to the policy that they had made for getting an MOU. Can I just hand on, my lords? I have served the government.
no.
Sir. They had filed a policy that MOUs can be signed for maintenance and work on the lakes. And to that, we have, my lords had in fact given us the liberty that we want to have any objections and suggestions also. So both we have made our objections and also some suggestions. And I've served a copy, and in fact, just one document, if I can, there's an advisory by the central government. If my lords can kindly see page 7, there is an advisory by the central government on conservation and restoration of water bodies, which the Ministry of Urban Development has issued. And in fact, one of the advisory provisions, if my lords can see internal page 11, the, my lords, page number. If my lords can see, ink page 20, sorry, my lords, ink page 20. Ink page 20. Yes, on the right-hand side, para 20. 20 on the right-hand side, what the advisory states is that alternate sources of funds for lakes will be welcome. However, the adoption of a PPP, like a public-private partnership, as an appropriate mechanism is to be developed, so developed that natural resources like lakes or ponds are not handed over forever and into the hands of private partners. A tripartite arrangement can be firmed up between A, the funding agency, which can be a private company or other sources, B, the government agency, that is city or state authorities, and C, implementing agency, that is a public trust or registered society with an impeccable conservation track record and competence for lake restoration. It could be a PPPP and would be more transparent. Now, my lords, why I'm relying on this is that the argument made is that we want even corporate entities to do the work. We need funding. They can take funding from a corporate entity, but the implementing agency should only be public societies or public trusts. The implementing agency cannot be a private corporate entity. And in fact, the suggestion we have made is that nothing stops them from taking money. In fact, even the advisory says you take money. If you want, you make a tripartite arrangement where the funding comes. BBMP monitors and work is done by a public trust, not a private entity. And lakes can never be handed over. So those are the suggestions we've made. But the implementation.
Nobody can give, nobody would give money then. If their
I
name
know.
is.
They will, with great respect, they will, because they can still get the credit of giving the money. Say, for example, a company like Wipro or Infosys or any company gives money. They can always say that this work is funded by and supported by Infosys or Wipro or any other company. But they cannot be given the work of doing the implementation. Because, or any, say, builder or developer company, they cannot be given the work of implementing. Because implementation for any lake-related restoration activities has to only be to a public trust or society which has a track record and doing it. And lakes can never be handed over. You can have a tripartite agreement where you can take funding from them. This is in fact an advisory. This was the basis on which, in fact, there's a prior order of this Honorable Court saying that no MOUs with private entities. That doesn't bar them from taking funding. If their whole grievance is that we don't have funds, you can take funding as per the advisory. So our suggestions, my lords, in fact, if my lords can just see the page 2 of my reply, page 2 of my suggestions, we've just made mainly 2 suggestions. Page 2, one is we have stated that in the definition section, contribution and in clause 3.5, contribution and entities cannot include private entities, private companies. And a suggestion we have made is that on page 3, that corporate companies should be deleted. And on page 3, number B, we have stated that there should be a specific provision that any part of the lake and buffer areas cannot be handed over to corporate entities. And relying on these, in fact, we have given a suggestion at page 4. They have made, my lords, in the policy, 2 kinds of suggestions of MOUs. MOU for services and MOU for building building assets. In fact, many parts at page 3, if my lord sees, para B, Roman 2. In fact, their policy states that they can build floating islands, treatment plants and parks in open areas adjacent to lakes. My lords, those are buffer areas. The lakes and its designated buffer areas cannot be intervened. And in fact, they have clauses in their policy which state that third party will not charge entry fee. Where is the question of entry fee? There is no clause which says lake will not be handed over. That is what is there in the advisory. It should be put that lakes will not be handed over. And while funding may be taken from a corporate entity, if they take funding, let it be a tripartite agreement where funding comes. But the implementation cannot be handed over to a corporate entity. Implementation should be with some public trust or a public society, which will only do the implementation work, my lords. And in order to, my lords, there is my lords, there is an order of this Honorable Court dated 4th March 2020. May I just request my lords, if my lords could see that order? Can I, I can pass on that. So, may I just pass on? 4th March order, para 10. My lords can just see. I've just highlighted it. In fact, 4th March 2020 order, my lords. Paragraph 10 at the bottom. In fact, when there were previous MOUs with corporate entities, this Honorable Court has passed an order which is subsisting, which says that there will be no such MOUs with corporate entities. And last line, this does not bar them from taking funding. But you can't have them implement the work. So relying on this, relying on the advisory by the Union of India, if they take the money and allow them to do the work, my lords, we lose the lake. We lose the lake. There have been those MOUs which this Honorable Court stalled. MOUs, my lords, were given to hotel companies like the Oberoi, where the entire lake, in the garb of improving the areas around the lake, were handed over. And in their policy, my lords, the policy that they've submitted, there is not a single line where they state that no, the lake will not be handed over. In fact, we want that to be inserted.
It's incorrect, my lord. She's repeating, they have stated it, my lord, will not be handed over. I don't know.
Let my friend kindly show that in the draft MOU
page
template.
13, my lord, page 13. I don't know why my learned friend is not pointing out that.
This order is passed in this very procedure.
Yes, this order is passed in this petition, my lords. When there were previous MOUs, my lords, this order stands. We have to certainly be in compliance of our lords' orders. And this order also says that this does not stop them from taking funding. By all means, take funding if companies are willing to give money for public lakes. But it should be limited to taking funding. We cannot involve corporate interests in work in the lakes improvement.
Yes, what do you have to say?
My lords, I thought, my lords, my learned friend will point out certain clauses in the agreement which has to be deleted.
Where is that agreement?
My lords, it was filed on 10th September 2024, my lords.
12th,
10th September 2024.
10th September.
10th September 2024. The agreement starts at page 11.
This proposed draft.
Proposed draft, my lords. As I mentioned on the day one, my lords, any correction, amendment, changes, we are open to it, my lords. We have nothing personal. The only thing,
It is filed on 22nd of February.
my lords, 10th September, court officer.
Which one? September.
10th September 2024. Court officer. Copy. Can you give one more copy, my lords?
Different date.
My lords, got it, my lords?
Yes.
Can I request page 11, my lords? Is the draft copy of the memorandum of understanding, my lords. First party is the government, my lords. Government, the state government of Karnataka, Vidhan Sada. Second is the BBMP, my lords. Third party and is citizen group, association, cooperative societies, NGO, company. The whole case of the petitioner, my lords, who claims to be public interest is company should not be made a party to it, my lords. They are saying that company should not be there. Your lordship may kindly see, whereas, my lords, A, my lords, first party is the owner of the lake. My lords, got it, A, my lords. B, second party is the municipal corporation, who is the custodian of the lake. B, my lords. In page 11 itself, my lords, page 11. A, right at the bottom, whereas, my lords, A, to the first party, that is the state, my lords, is the owner of the lake, which through notification GO has handed over the custody of the lake to the second party for conservation, development and maintenance. B, second party is the municipal corporation of city Bangalore, is the custodian of the lake by virtue of notification passed by the first party. The above parties are collectively referred to as state parties whenever required. The third party, in response to public notice, has approached the first party and offered to for by way of application so and so. Each of the parties are referred to so and so, so and so, so and so, my lords. Then, my lords, can I request my lords to turn to page 13, my lords. Term, the MOU shall be valid for a period of -1 date from the date of execution. It's a limited period which we are giving to them, my lords. Page 13. Page 3, page 13, term is for a period of whatever the period. 3.2, term shall lock in period of 6 months. The parties have mutually agreed in writing for approval. OC, third party shall coordinate the nodal officer under the CICL policy of 2024, who shall oversee and supervise the third party's performance of the terms of the MOU. Relationship, the parties undertake and agree, the third party is acting as an independent capacity and the third party's affiliate, subsidiary, subcontract agent assigned is neither an affiliate, employee, agent or subcontractor of second party or entitled to any benefits from the second party. The third party does not have authority to act for the state or bind the state party in any respect whatsoever to incur any debt, liability in the name or on behalf of the state parties. The second party here shall retain absolute custody, control and supervision capacity over the performance of third party's obligation hereunder and control over any persons employed or contracted by the third party for providing facility by assets therein. The present MOU no means shall be interpreted as giving any lease right or other right, interest or title to the third party in respect of the lake, in respect of which the present MOU is being executed.
Second party is not obliged providing any training. So, my lords, we have made it very clear, my lords, they have absolutely no right over the property. If the language is not apt, my lords, we are open to using any suggestion from your lordship. So therefore, third party has no right at all, my lords. What they're doing is, my lords, we call for a notification for the nature of work to be done, my lords. What each lake depends upon what for conservation and rejuvenation, what is the work to be called, we will call for expression of interest, that work is done. 5.6, neither party nor is the applicant will receive any benefit from the state parties. Para 14, page 14, 5.7, my lord. The facility by assets is provided at the cost of third party, and third party shall take precautions necessary. The party shall proceed. So and so, my lord. Then, my lord, page 15, page 15, my lord, 7.6. 7.6, my lord. Third party is provided from charging any entry fee to the lake or engage in any commercial activity, including food hawking, selling lake water or water tankers. Third party is prohibited from utilizing the water from the lake for any other assets of the second part activities as engaged in the MOU. The third party shall have no right to conduct any religious activity in the lake. Third party shall whatsoever shall not any commercial activity. My lords, without reading this, my lords, all these aspects, submissions are being made that will give it to Oberoi's. Well, I mean, our interest, I would welcome, my lords, any addition, any clause, absolutely no problem, my lords, so that lakes are protected, my lords. I mean, it's not an adversarial litigation, my lords. There are nearly 185 lakes which requires, my lords, urgent to be taken care of. Then, my lords, 9.3 and page 15. Once such 9.2, my lords, once the facility by assets have been completed in all respects and in compliance with the submitted application proposal by DPR, the nodal officer shall certify that the facility by asset is ready to be handed over from the third party to the second party. Upon the certification by the nodal officer handing of facility, the second party, the contributed facility shall become the absolute property of the state parties, the state government and the BBMP. Upon such handover, the third party shall have no right, interest, title claim or interest in the facility by assets. The third party shall however be liable for conducting repairs by replacement during DLP. So therefore, my lords, there's absolutely no reason for any apprehension, my lords. And as I said, at the cost of repetition, my lords, you tie our hands, no problem, my lords. We are not into the. Kindly permit us to enter into this MOU so that the lakes are protected, my lords. That's all my submission.
May I just make one response since my lords has the draft MOU? May I just refer to 8.1 for a moment? My learned friend read out some of the other clauses. May I just refer to 8.1? 8.1, the third party shall mandatorily obtain all requisite sanctions, permissions, and pre-clearances from KTCDA and second party prior to beginning work on any installation of facilities or assets in the lake premises. My lords, kindly make a note of that. So that means their third party, and if my lords looks at the definition of third party on page 11, what all is included as to who all are third parties? Third parties includes association, cooperative society, NGO, company, which means a company can also start work in the lake premises. You may say that you don't have leasehold rights, but you're giving possession of the lake. You're giving someone the possession to enter and do some work in the lake premises, my lords, which is completely prohibited both by orders of this Honorable Court of March 2020 and also the advisory, which says that here the same third party is the contributor of money and the implementer. So therefore, my lords, these are the difficulties which cannot be.
Just 2 minutes, I'll not take more than page 20 of my learned friend's advisory maybe can you see? It helps us, my lords. Page 20, para 20, man. All alternative source of funds for lake will be welcome. However, the adoption of PPP as an appropriate mechanism is to be so developed that the natural resources like lakes, ponds are not handed over forever, which we,
Where you reading?
para 20, Manoj, which is my learned friend was relying upon.
The
Page 20.
advisory which I submit.
Their objections, Manoj, page 20.
Alternate sources of.
Please, please. Alternative source of funds for lake will be welcome. However, the adoption of PPP as an appropriate mechanism is to be developed that the natural resources like lakes, ponds are not handed over forever and into the hands of private parties. That we have clearly mentioned, Manoj. You also may pass a judgment also on that aspect. We have, necessary orders. This is a tripartite. A tripartite agreement can be formed up. A funding agency, private company, it is permitted, Manoj, private company, or any other sources, be the government agency, city or implementing agency, public trust, or a registered society with an impeccable conservation track record, competent for lake restoration. It would be PPP and would much be more transparent. Here, what we are seeing, Manoj, once the fund comes, Manoj, there is a likelihood of misappropriation of funds. We don't want to deal with the funds, Manoj, so that instead of taking money from the BBMP and there's misutilization of funds, what we are saying is you conserve, you maintain. It's your money, you do it and you maintain. If one, because each lake requires different needs, Manoj. There are only 185 depending upon the size. So they say that you come forward, it's your money, you maintain it, we'll supervise it. The clause which was read, Manoj, show the plan what, before you do, show the plan what you are doing. Unless you approve it, you don't do any work. So that is why 8.1 was included in Manoj. And the whole area is lake area. No commercial activity, as I pointed out, Manoj. So therefore, ultimately, whatever is being done is within the lake area to preserve the lake. There may be a bund, Manoj. And I'm hope your lordship may appropriate suggestions or directions may be issued, Manoj, will be implementing, Manoj. There's no, if your lordship feels any corrections is required in the MOU, Manoj, so that the purpose is served, Manoj.
So you are proposing to endure all the lakes or certain category?
No, wherever all the lakes, Manoj, wherever if required and what is required, Manoj, because some of them are maintained 90%, they are there and depend, and it is not that for maintenance, Manoj. For example, Manoj, in some lake, desiltation may be required. We'll give only that portion of it to be done by them. Based on the.
If you go with that, then you will have to execute the contract separately.
MOU separately with each one of them pertaining to each lake.
Depending upon the requirement.
Absolutely. Please,
for that lake.
Please, my lord.
My lords, the principle in the advisory and in my lord's previous orders are, core principle is the funder cannot do the implementation. Implementation has to be done by an expertized body. A person who does desilting may not have the funds. Your corporate entities who are running IT companies or any other entity who has the funds of giving to the lake will not be conservation experts. So the principle is that the lake cannot be handed over to a corporate entity. You may take money. It does not bar alternate funding, but even if you have a PPP, your funding agency is one and your implementing agency is another. Here, what they have done is the third party is only one entity who will put the money and do the work. My lords, therefore, this makes the public interest at risk. You are having an entity which may have real estate interests. Now, my learned friend may laugh or whatever.
Such submission should not be made.
No, we are, my lords, once an MOU is executed, do we have control? We don't have control. We are only, nobody has a public interest, nobody has a private interest in this. This is not adversarial, but we have to keep the environmental interest in mind. That is all the concern is. So therefore, let the framework of the MOU has to be changed. You can have a funding party. You can have a fourth party, which is a funding party, and a third party, which is the implementing body. And there has to be a requirement that no installation will be done in the lake or the buffer areas. Grateful, my lords.
just page 5, my lord, and to answer your lordship query, your lordship wanted to know page 5 of my application, my lord. The policy we have, that is there in what your lordships asked me, my lord, it's already there in page 5. On 10th September, page 5. For the lakes where detailed, my lord, got it, page 5, para 5. For the lakes where detailed project report has been prepared by both Bangalore Mahanagarapalika has been approved by Karnataka Tank Conservation and Development Authority. The entities elected to contribute may, from the schedule of expenditure mentioned specified in respective, opt to contribute towards any of the items expenditure or all of it based on the private entity's area of expertise by interest. Prior to undertaking such expenditure, Malos, therefore, Malos, what you are saying is, and is approved by Karnataka Tank Conservation and Development Authority, Malos. It is, that's very important. The project report, what is prepared, it is approved by the authority. And there is an act also, Malos, called the Karnataka Conservation Development Authority Act. Their powers and functions, they act strictly. Unless it is approved by them, Malos, we will not go ahead. The reason is it's already been delayed for so long, Malos. That's why we are insisting. Section 6 of the Act may be kindly seen, Court Officer.
6 of?
Karnataka Tank Conservation and Development Authority Act. This is the authority which will approve each of the projects, functions of the authority, Malot. That is at clause 5. Clause 5, section 6. Section 5, subclause 5. To prepare a plan for integrated development of the tanks and monitor the expenditure and development of the tanks. They will do that, Malot. And 5, subclause 5, Malot. To provide a plan for integrated development of tanks and monitor the expenditure and development of the. Section 5, subclause 5.
Section 5, yes.
Subclause 5. Subject to the provision of this Act, the rules, therefore, the functions of the authority shall be to prepare a plan for integrated development of tanks and monitor the expenditure and development of the tanks. Then can I request clause 6, Malot, 6 subclause 2, section 6 subclause 2, subject to the provisions of the Act and the rules made thereunder, power of the authority shall be to receive grants, donations, contribution, deposit, rents, and levy of fees or charge for development and maintenance of tanks at such rate approved by the government. Then 3 is important. To grant clearance to any project proposal made by any government department, organization or association or person interested in developing, maintaining, conserving or protecting a tank, and also take up such activities on its own which shall be approved by the government. That is why clause 8.1 has put, my lord, saying that all permissions and approval has to be taken. And your lordship may note, my lord, that we will not violate, and clause 12 may be kindly, section 12, my lord. Section 12 may be kindly seen. Acts prohibited in tanks. Acts prohibit, notwithstanding anything contrary contained in any law for the time being forced, no person, institution, organization, registered or a company or a firm or an authorization, government department, corporate or any other local authority and their agents or employee or any body thereof shall, Malot, these are the various conditions, Malot, use the tank for the purpose of storage, construct any structural tank, occupy any tank, make construction or carry out commercial or recreational activities within 30 meters of the boundary, dump debris, discharge untreatedly, construct road, bridges, so and so. We will comply with, we are bound by this act, all the provisions, we are aware of it. Authority comprises of. And if I may request, my lords, your lordship may kindly turn to section 3, my lords. Section 3 for. That is the constitution of the authority, my lords. Section 3, subclause 3. The Karnataka Tank Conservation and Development Authority shall consist of, my lords, very high dignitaries, my lords. So therefore, my lords, they'll, in fact, as we have put this, that their approval will be taken every time, my lords. So that, my lords, there's some sense of seriousness in the whole issue, which I read out through to your lordship, page 5, paragraph 5, my lords.
So you'll be drawing power to enter into the MOU from section 6(2).
Please, my lords. 6.3. 6.3, my lord.
6.3, 6.3, sorry, 6.
Section 6. Well, therefore, ultimately, my lord, what, I mean, there's no real estate, there's no hotels, absolutely nothing, my lord. And the person who will be best utilize the money is who's giving the money, he knows the value of the money, my lord. So therefore, he'll use every penny to maximize the benefit. Tomorrow, if I give it to a third party, my lord, he has no value. For example, it costs X, he'll value it double, my lord. So therefore, my lord, the person who's paying the money, let him, whomever he's entrusting it to, let him take care of it. Neither the BBMP, my lord, or the state or third party will be in the right position, my lord. In fact, it is well thought of, my lords. For example, my lords, if the money is given, then maybe if we had taken the money, they'll say misappropriation may arise. Therefore, my lords, I leave it to your lordships, my lord, any suggestion is welcome.
In fact, sorry, 1 second, sir. My lords, clause 6, section 6, sorry, of the act, what my friend read out, section 6(2), two provisions are there. One is 6(2) states power of the authority to receive grants and donations, contributions for development and maintenance of tanks. So they can in fact receive grants. There is no, so if they want to receive funds, they can receive funds. After receiving funds, they can give the, they have the power to give any other person, whoever is having any expertise to work. And then, my lords, there is also the under section 12, acts prohibited in tanks. Acts prohibited in section 12. In fact, it says, notwithstanding anything to the contrary contained in any law for the time being enforced, no person, institution, organization, or a company or firm or association or government department or agency, etc., on their behalf shall, 2, construct any structure on tank land, occupy tank land, or part with, and then 3, make any construction or carry on any commercial or recreational or industrial activity within 30 meters from the outer boundary. So lake land and 30 meters, which is the buffer area, no construction can be carried on. My lords, when no construction can be carried on, how can an MOU say you will construct facilities? Any facilities or assets is construction. Even if you are putting up some boundary wall, it is a construction which is not permitted in 30 meters of the boundary. And second, even if they give approval, my lords, they can only give approval for a corporate entity to fund, not to construct. My friend says this is thought through. My lords, this is thought of at the central government level. And the advisory says you can only take funds. You can't do anything else. Apologies, made my submission.
I appear in number 8.4. I filed my objection to the memo filed by the government. The first thing is that your lordship, page 4 of the memo filed by the government. The Karnataka Time Development Authority, they have already objected because unless the 4th March 2020 order is modified or approved, it cannot be decided. Because another aspect, your lordship, is MOU, now draft MOU. It cannot be between the government and the BBMP. Because since it is a Karnataka Tank Development Authority Act is still there, it can be only through Tank Development Authority. It cannot be by any BBMP or any, because they don't have power at all. Because BBMP is only custodian of the lake and other property. And it can be only between government and the Tank Development, because they are already objected. It cannot be done without the modification of the earlier order passed by the fourth party. So this MOU cannot be between my responsibility. It can be only by the Tank Development. They can, because they are the authority who has to maintain the lakes and other things. And funds also, they have the power to receive. So unless that there cannot be any policy as far as BBMP is concerned. Unless the Act that does not provide for such things in the Karnataka. Section 12 also section 6 or section 5 of the Act.
With the kind permission of the court, my lord, I represent respondent number 14 in this matter. And this is a community group which has been looking after one of the lakes in Bangalore for the last 12 years in an MOU with BBMP. With the implementation of this policy and preference being given to corporate entities, the community groups will lose out. If there may be an observation to protect the interests of these community groups, which are already looking after the lakes, we will be most grateful.
They have equal rights, my lords. Nobody has got no rights. Anybody can
But-
come and treat everybody equally, my lords. It's ultimately whoever is, we have no special
But my
interest in
lord,
it.
But my lord, with reference to the corporate entities, they will have superior funding. They may have better claim to funding, but they may not have better claim to community interest, which is the local community. And the entire policy is called community involvement in lake improvement policy. And to exclude the communities will not be in the benefit of public interest.
My lords,
Respondent number 14, we have filed our objections as well.
page 18, my lords, of my application. We have a page 18, my lords. Please, my lords. Please, my lords. I'll go 18, page 118 I have got. 18. Exhibit A, description of facility in application submitted by third party. My lords, when we give an expression of interest, my lords, when what are the works to be done, we make it part of the agreement to say what is going to be done, my lords, based on that. Well, it depends from lake to lake, my lords, what it is. My lords, okay, your lordship may kindly, I understand where your lordships are coming, so that there's no, your lordship, can I give a list of what are the nature of work for all the lakes and which, and your lordship may point out which I'll do that. my lords. Page 4. Your page 4, it is there. My learned friend is saying, my lords. Page 4 is there. Please, my lords. Page 4, para 4, my lords. It's already stated, my lords. I'm sorry. Your lordship kindly restrict us to only to those aspects, my lords. The entities may, with the prior approval of the BBMP, page 4, para 4, the entities may, with prior approval of the BBMP, elect to incur expenditure from its own funds on behalf of or for the benefit of the BBMP, develop, create, provide a facility or asset to be used by the BBMP for its lakes, or to offer services on behalf of the BBMP to develop, maintain the lake. Illustratively, such assets include the installation of benches, construction and maintenance of public restroom, installation of water treatment plants, providing aerators, providing floating islands for lake rejuvenation, and creation of park and open spaces adjacent to the lake, etc. Illustrative services purpose of lake maintenance include the housekeeping and arrangement of cleaning of the lake, maintenance of public service in the lake. These are the illustrative which we be part of schedule 2, my lord.
This is all construction in the lake and the
Not
buffer
in the
areas.
lake, my lord.
Then where else, my lord? Floating islands is in the lake. Buffer areas is in the lake.
My lord,
Construction of
with your lordship may kindly see
are in the lake. my lord.
misinterpreted. Your lordship may kindly see floating islands for rejuvenation. My lord. It is not an island. It is put. There's no full stop there. For example, my lord, there are machines which we put it on the in the lakes, my lord, which cleans the lake. I mean, there should be some sense of responsibility in making submissions, my lord. Floating islands for lake rejuvenation. My lord, your lordship may kindly read it as a whole. And we are not going to create an island. My lord, we are more interested than the petitioner in maintaining these lakes, my lords.
Yes.
Please, my lords, absolutely. And if you want, my lord, as your lordship directed me, my lord, I'll place additional affidavit, what I'm going to actually give in detail. If your lordship feel that should not be there, your lordship may delete it. Yeah, we'll place it. Common, absolutely, my lords. Absolutely, my lords. Absolutely. I'll do that, my lord. In addition to that, I'll identify and place. We are open to scrutiny, my lord. And your lordship may say that anything going wrong, they may approach the court to point out that to your lordships also. My lord, these are not only the petition, any public can come before your lordship to point out, my lords.
My lords,
And one other, just two other submissions, my lords. In the affidavit dated 22nd February, my lords, what we have stated is, my lords, where is it? We have stated at page 2, the commissioner has given an affidavit. The ownership and the custody of the lake will not be transferred to any such entity and would remain with the state and the custody of the BBMP. It's void. I mean, I'm just trying to answer my learned friend's apprehension, my lords. It is vested with the BBMP, and we have, and please, my lords. Any 8, my lords, no. 8.
And my lords, let the advice, 1 minute, sir, let the advisory. But my lords, let the advisory and the previous orders of my lords be taken into account is my humble submission. Yes, that is our submission. Let those issues be taken into account, that companies not be handed over. We are at my lord's hands.
For yearly, we need 650 crores, my lord. I've got the account statement for each day, what is being spent, my lord. If under the CSR funds or any person who can give these funds to maintain, we can use these funds for some other public good, my lords. And here the question is, and as well as keeping in mind the.
Keep it in AD's.
Nothing bars them from taking money. Absolutely nothing bars them. What bars them, what limits are imposed is who can work on the lake and how can the lake be
maintained without corporate entities. That is the concern. That doesn't bar them from taking money. That is our submission. My lords, while the advisory clearly states if there is an entity that is willing to donate funds, they can take the donations. Even the Act permits taking of donations. They can also advertise the donations that so-and-so entity has in fact given the money so that that entity gets the credit. But working on the lake should be those who are in the advisory, either public trusts or registered societies. Because under the supervision of the authority, but not corporate entities, not corporate. We have supervision of authority is there, not corporate entities. Yes, not corporate. Our restrictions.
I've got doubts, I have serious doubts, my lord. It is these entities are, your lordship asked a question, whom it should be given. That's the $1 million question, my lord. The question is, if we give it to XYZ, again a tender has to be called, my lord, after giving it. If we give it, my lord, then the question is who's going to manage it, whether they've actually utilized this.
To do it.
No, I think, my lord, there's some other interest to point out to give it to. I would understand if your lordship said that don't give it to anybody, give it to the person whose money it is. When the person, if you're giving it to any third party, my lord, they have no interest at all.
If the minute someone has money, they have a commercial interest. I have given 10 crores. I want to see how my 10 crores is utilized to almost 20 crores. Someone who is doing the work in the interest of the work has no commercial interest. But the minute someone puts in money, they have a commercial interest, my lords, and it can be supervised by BBMP.
CSR, Chapter 7, Clause 4, Clause 2 of the Companies Act.
Their funding will be for social responsibility. But someone who wants to give CSR funds is not an expert on environmental or lake matters. Any company, by giving CSR funds, they may want to give the funding and they may want to do something for the city. But my lords, they may not have the expertise or even the interest towards the lake. They may just want to give it for CSR funds. You should utilize it. There is no harm.
Yes.
Yes.
Correct. That is Schedule 7, Section 130.
With great respect, CSR requirements are there under the Companies Act, which say that X% of amounts have to be given by each company towards CSR. But that is only limited, my lords, to giving the money. If we take money from company X as per the advisory, you should give the work, implementation of the work to entities which have an expertise. Can some tobacco company who gives CSR funds, will they have an expertise or will they have any interest? They are a corporate entity, my lords. Should not be working on the lake, my lords. That is the advisory, that corporate private parties should not be working on the lake. That does not limit them from getting their funding. My lords, let's keep it separate. We are more than happy if corporate entities give funding to the BBMP for public use. Let them take the funding. In fact, the Karnataka Lake Conservation Act says that they can receive donations. Please receive those donations. Even the advisory says receive the donations. But, and you can also advertise who has given the donations. That is all that the corporate interest is there. We have to ensure, my lords, that the lake is protected for the public. How do we ensure that, my lords? There should be no construction in the lake and the 30 meters buffer area. There should be no handing over of the lake land to any third party. Whoever they buy a tender to do the work. Yes, that's
That's a, we'll be bound by that.
Compliance.
Yes, definitely, Manoj.
And that is why my lords had passed the orders that you can't have MOUs with companies. You take their funding. It doesn't restrict them from taking funding, but no MOUs with the private companies. In fact, there were about 10 MOUs, which were all halted by my lords. We cannot, having this recognition, revive, my lords. Ultimately, the responsibility of the lake is with the BBMP. Yes.
Manoj, really, Manoj, just one submission, Manoj. What your lordship, Section 135 of the Companies Act, Manoj, Schedule 7, talks of activities which may be included by companies in their cooperative social responsibility policy. Subclause 4, ensuring environmental sustainability, ecology balance, protection of flora and fauna, animal welfare, agroforestry, conservation of natural resources and maintaining quality. So they, please, my lords, absolutely. So therefore, my lords, again, my lords, this argument, my lords, give it to some, these agencies. Then I would say, my lord, give the list of agencies. That means they have no vested interest who are doing all this, my lords. They are not interested in the lake. My lords, therefore, my lords, we'll point out, my lord, schedule B, what are the work to be done, my lord. Let the, whoever is not only companies, I forgot one point, my lord, with my learned friend sought to agree. In the event of BBMP receiving multiple applications from numerous entities in respect of the same services, facility and asset, a committee as mentioned in clause 3.4 shall evaluate all the applications based on the relative experience, expertise, financial capability, resources of each entity to select the more suitable entity. My lords, it is not companies, we are not, and the decision of the BPP in that regard will be final, the validity periods will be fixed. We have stated that, my lords, in page 5, para 7, clause 7 of a part of our policy, page 5, para 7, we have clearly stated, my lords. And by chance we give it to anybody ineligible, all that is subject to judicial review, my lords. And if you go wrong, we are always before your lordships. And there's an authority under the Act, my lord, which supervises what is permitted, what is not permitted. And this petition has been going for nearly 10 years, my lord. Page 5, clause 7 of my objections filed on 10th September. That is section 35, schedule 7, my lord. Section 35, schedule 7, clause 4, my lord, of schedule 7. In fact, my lord, I mentioned it, culled it out also part of my application, my lord. First page, schedule 7, my lord. It's page 1, para 9 of my memo dated 10th September. 10th September, my lord. I'll give, and in fact, I'll give it to my learned friend also, my lord. She can also go through, my lord, have any. Please, my lord. Each lake, please.
What submission? My learned advocate read about the page 8, clause 4, you will of the memo, clause 8. And that they have to provide benches, construction of maintenance, public, page 8, you will. Okay. So that is prohibited under section 12(3) of the Tank Conservation Development Authority Act. Clause 4.
Page 8 of what?
In the memo filed by the government. Okay. Contribution of facilities services.
Page 8 of draft policy.
No, they say construction of park.
You read it.
And open spaces adjacent to lake, etc. This is what it says here.
Page 4. Page 4.
And
Read it.
yes, if you look into section 12(3) of the Act, which has been amended, Karnataka Tank Conservation Development Authority Act.
12(3). Yes. Read it.
Section 12, subclass 3.
Yes.
Subsection 3. It has been amended in 2018. Make any construction or carry on any commercial or recreation or industrial activity within 30 meters from the boundary of the lake. That's what buffer zone is. So no activities are permitted in the buffer zone, 30 meters. Beyond that, that is not, because they can do it. Not, that is the intention is that to see the.
For whosoever develops lake, either government authority, agency,
They can't
private party, corporate sector, has to abide by all these things.
It cannot be inside the lake.
That is,
It is construction agrees or inside the lake.
that goes without saying.
Clause 6 may be kindly seen, clause 6. Construct road, bridges and allied works within the tank area, including the tank bond. The authority may grant such permission for such works only after ensuring the original capacity of the lake is not reduced, even after such work.
Original capacity of tank.
That much, we are all bound by this.
By constructing this, lake area is reduced, you know. No. Can be only up to the buffer zone. It cannot be within the. That's my responsibility. No can be take place.
According to you, who should work with the lake? Madam.
Yes, my lords, the only agencies or entities that can work on the lake for any lake restoration or protection or improvement would be entities which the BBMP engages. They can be private vendors, they can be community organizations, but they cannot be funders. In fact, the responsibility of the lake is with the BBMP. They're still doing desilting work, etc. They may engage third-party contractors, for example. In this MOU, this is a community involvement MOU, a policy. If they want to involve the community, there should be resident associations. My lords, kindly see the title. The title is Community Involvement for Lake Conservation Policy. They want to involve community. It actually means residents groups, neighborhood groups, watch groups, public societies or public charitable trust who will do a watching or maintenance of the lake. If they want any private contractor to do some desilting work or some other cleaning work on the lake, BBMP's responsibility, they are the custodian of the lake or the tank development authority, they can definitely engage third parties. They can't say you bring the money and you do it. Your funding has to be separate, which is what the advisory says. You can't have corporate entities who will give funding and then are given permission to enter the lake premises. That is what the advisory says. If you want community involvement, please engage only resident groups, NGOs, registered societies.
My officers will be very happy with that.
My lords, the onus on the lake is with the BBMP. They cannot palm off their responsibility. They are the custodians of the lake.
After development of the lake, who will be regulatory?
It will be, in fact, they have to regulate. In fact, even if they hand over to do some work, my lords, even today, they don't need this permission. They needed this permission only because there is an order of my lord saying that no MOUs with corporate entities.
Let us say we'll think it over.
That's why we are opposing the lordship. 4th September 2026, the Honorable Court passed a detailed order. Based on the time frame is given how to maintain the lake, how to remove all the obstructions or constructions on the starboard drain. So that has not been completed until Tuesday. Time frame was given by the Honorable Court, 4th September.
Yes, 8.
One second. My lords, what date are my lords?
Grateful to my lords.
My lords have given some date, my lords.
8.
My lords, if some 11th, my lords, that week I'm not there. 11th, my lords, grateful. Great. 11th November.
Number 9.
Madam Lord, regarding the non-filling of the vacancies in the health department, may I persuade your lordships to see, Lord, the alarming situation in the state prevalent. May I persuade your lordships to see, Lord, the state government's affidavit file. Fine. Oh, that's it. May I persuade your lordships to see the
my lord, vacancy position prevalent in the state. The state government has filed a response, my lord, on 29/7/2024. In that, my lord, annexure R1, page 14, page 14 of the objection, statement of objections filed by the state government, my lord. Lordships will see sanctioned vacancies as against which, my lord, the working strength. Page 14, my lord, annexure R1. Lordships got it. Lordships got it. Page 14, medical officers posts. Lordships may see, my lord, page 14, column 1, medical officer 2,355 sanctioned posts, working hours so and so, then 605 posts are vacant. Then specialist, my lord, only 744 as against 2,877 are working. And as Lordships will see, junior medical laboratory technician, 2,324 as against which only 624 are working. Now, as your Lordships come down,
Working
the situation is
1,682.
Kindly see, my lord, group D posts 16,897 are the sanctioned posts and vacant posts are 10,253. Vacant posts are 10,000. The one which I read, my lord, are the vacant posts. Now, the column, my lord, vacant posts as against the sanctioned strength will indicate that, my lord, there is an alarming shortage of health workers at all levels. Column number 5 is the vacant post, my lord. 605 vacant posts of medical officers, specialist post 744. As your lordships come down, the group D workers, around 10,253 vacant posts are, my lord, pending. And as we go, my lord, up, even the specialist posts, dentist, senior medical laboratory are all vacant. This is, my lord, one situation. Now your lordships may kindly see, my lord, the writ petition and why I have pointed out, my lord, this situation has further aggravated is page 52, annexure E of my writ petition. The act, my lord, page 54, Karnataka compulsory services by candidates completed medical courses, amendment ordinance 23. Lordships got it, my lord. Page 54 of my writ petition. Now, what was page 54, annexure E, my lord? What was happening, my lord? This alarming deficit of health workers was prevalent all throughout. But because, thanks to this act, which was prevalent prior to the this act, the ordinance, the compulsory rural medical service was, my lord, adopted. And this honorable court in various judgments upheld the constitutional validity of the amendments brought about to make the health workers' participation compulsory, the medical students' participation compulsory. Now this rural service is removed. So once, my lord, the compulsory rural service is removed, then, my lord, they have to make regular recruitment. They cannot say that this compulsory rural services is dispensed with, yet we will not appoint the workers. I am not questioning the legislative rationale of, my lord, bringing this ordinance and removing the compulsory services. Let them, that's, my lord, state policy, state prerogative, legislative policy, my lord, I bow down. But having brought in an ordinance in 2023 with such alarming hurry, removing the requirement for the compulsory rural medical services, they should have filled up the posts, which are, my lord, especially the group D posts and the lab technicians and lab specialist posts, which are extremely crucial in the times of, my lord, the pandemic, in the times of health crisis. So this is not happening, my lord. And state government has said that they will issue tenders. Also, what is happening, my lord, in annexure R1, which I read, this is also crucial.
at page 14 of the objection statement that I read, just my lord, persuading your lordships to revisit that annexure for this reason. Kindly see, my lord, column number 7 in that objection statement. This is compulsory rural service. Now they say that medical officers, 2,337 posts, they want to fill up through compulsory rural service. I showed to your lordships that compulsory rural service is not done away with. This 2,000 is not, they cannot fill it up. So now 605 posts are remaining, and it is not an ever increase. The sanctioned posts itself need to be increased because of the rural areas and semi-urban areas where the health workers are in utmost need. Now they are showing that due to compulsory rural service, this is they propose to recruit 2,371, which is now done away with, because thanks to that ordinance where the rural service itself is done away with. So my respectful submission is threefold. One is, let the government, instead of filing an objection statement, and they are a great job is done, they are very openly and transparently said that about 16, as a vacant, there are about 14,523 vacant posts at all levels. Page 14, which your lordships are reading, the last total column your lordships may see. So let them come out with a plan that when do they propose to, fill up these vacancies of 14,523 at various levels. One. Secondly, the fund utilization also, is a major concern. That's why, National Health Mission is a mission, the central government started, and there is adequate funding being received. Whether that fund can be utilized for filling up these vacancies, the state government's classic response in all these matters is that we don't know, we have fund crunch, we have fund problems. So there is, the central government is also party before your lordships. Let them come and say that this is the amount expended or released for National Health Mission. And with this, they can give a roadmap before your lordships that when do they propose to fill up these vacancies, crucially at Group D level and nursing officers level. Nursing officers, 7,455 outsourced employees are working. About 906 vacancies are still vacant. So 75% are, in fact, your lordships may see 10,000 vacant posts as against 16,000 Group D posts. This is an alarming situation prevalent in most PHCs. Lordships may take judicial notice. In the city areas, we don't normally notice it. But mostly the Group D workers and the lower category health workers are the bedrock of the rural health needs. And if this is the alarming deficit of health workers, the vacant post of this kind, the state government has to work on a war footing basis and come out with an action plan instead of coming out with an objection statement that within this period they propose to fill it up.
My lord, I have in my statement of objections, internal page 3. My lord, from page 3, my lord, till paragraph my lord, till paragraph 9. My lord, I have explained the details of posts in Health and Family Welfare Department. Each and every contention that is raised, I have met that. My lord, and even with regard to, my lord, filling up the post of D group employees, my lord, I have made a submission. My lord, the internal page 5, my lord, the 5th line from the top. My lord, the first sentence itself may be read. Paragraph 7 may be seen. Paragraph 7. Page 4. My lord, may I read, my lord? It is submitted that as far as Group D employees are concerned, the sanctioned posts are 16,897 and 6,644 persons are presently working on permanent basis. 10,253 posts are vacant. As per the government order dated 24/6/2019, up to 75% of Group D vacancy, non-clinical stroke Group D staff, 4,201 in number, are recruited on outsourced basis at each district commissioner, revenue
level and they are presently working on contract with the National Health Mission project. 1,500 persons are working as the group employees. Then my lord may take, my lord, paragraph 14. Page 9. My lord, I have met each and every contention and I have stated, my lord, at what stage the vacancies are. Paragraph 14, it is submitted that for filling up of the sanctioned post of the medical personnel in Karnataka state, the state government made all its endeavor and has taken all steps to ensure health schemes are run effectively, and all the steps have been taken in implementation of the order dated 7/11/2023 passed by this honorable court in this writ petition. The vacant posts as on date shall be filled as and when approvals for filling up are accorded either through direct recruitment mode or contract or outsourcing mode.
In what time you propose to fill?
And
My lord, the vacant post should come.
one submission, my lord, before your lordship poses that question. Sorry. Even if we total up para 7, I'm grateful my learned friend read out. 1,005 plus 4,201 totals up to around 5,206. Yet, my lord, around 6,000 vacancies are open. Secondly, my learned friend read para 15. Kindly see, my lord, the latest position. As per the said statistical data, I'm reading para 15 last 3 lines. As per the state statistical data, total number of vacancies is approximately 16,249 and number of vacancies filled up under contract basis is 16,501. So now, my lord, if this is the answer that I will take this on an ad hoc basis or contract basis or temporary basis, this is, she has met the contention of the state has met the contention. But if this is the answer that the permanent requirement and such a crucial need like health is being met with, my lord, contract employees or at these levels, then, my lord, it is no answer. The sanctioned strength itself has to be, at least the permanent recruitment has to be made to these posts. Also, your lordships will see rural health. Now it has to be further augmented because they have done away with the compulsory rural service requirement at village levels. Then whether they have to revisit now whether the sanctioned strength itself is adequate, because the sanctioned strength was on the basis that there is a compulsory rural service available. In fact, the sanctioned strength was in the regime where the compulsory rural service was not compulsory, was in vogue.
My lord, paragraph 20 for a minute with regard to the funds may be seen in my statement of objections at paragraph 11.
And
my lord, I've been honest and I'm saying this is what, and as and when the vacancies come, my lord, we will make an endeavor to see that they are filled.
The compulsory rural service, the paragraph, my lord, in which I have dealt has not been answered. 3. Para 3.15, no answer to that. Let the state government take a stand on that is, my lord, what I have been saying from day one. Para 3.51, no answer. Page 11 may kindly be seen. After 3.14, they straight away go to 3.17. Specific response to the compulsory rural service being done away with, and how in the alternative, in this kind of a situation where they have done away with the rural compulsory service, is to be met is not answered. Kindly see, my lord, page 11 of their response. Straight away from 3.14, they straight away go to 3.17. Those 3 paragraphs in which I made a specific allegation, a specific averment, I would say, I'm sorry, the word used is wrong, but the specific averment regarding the rural compulsory service being dispensed with is not answered. All that I'm praying is, my lord, the lordships may direct them. I am not questioning their legislative stand or, my lord, why they are doing it. That's their wisdom. That's they are, my lord, elected representatives, executive is, my lord, the best decision maker. But let them take a stand. Whether in the wake of they dispensing with the compulsory rural service of the medical students, whether they need to revisit the sanction strength
or what other alternative, effective, efficacious alternative policies are devised to take care of that situation in the alternative regime that we are in. That's all I'm praying, Lord. Specific to that, 3.15, 3.16.
For Union of India.
And their funds are, my lord, the oxygen. Because rightly pointed out by my learned friend from the government, the National Health Mission workers are working, my lord. They are filling up those vacancies. So let the central government be not complacent with the release of funds that so-and-so crores are released in National Health Mission. How many workers are required? Whether National Health Mission funds itself may need to be augmented to the state to bridge this Lord, alarming gap of Group D workers, particularly. Let central government also take a stand that their employees, because they fund it, as my learned friend was arguing the other time. You fund it, you take the responsibility of just funding it and not keeping quiet won't do it. Let the central government take a stand that this is the amount we have dispersed in the National Health Mission. And we direct the state government or request the state government to fill up the vacancies in this time period or timetable or whatever target. These are
that also have met in paragraph 18.
No, I'm asking central government to take a stand on that.
What the central government has released.
We are supposed to support the state government by channeling funding towards the state government. The health as a subject lies entirely in the hands of state government, I submit.
The National Health Mission is not a central project. The funding is done by center. And their funds have to be utilized. They have to monitor whether those funds are effectively and rightly channelized. That is only central government's role. I leave it at that.
My lord, paragraph 18 may also be seen, my lord, 18 and 20.
It's not an adversarial thing, but I'm not.
No, but what you're saying is taking us by surprise. Even 17, I have stated that.
How the whole process started, may I persuade your lordships to see 10/7/2024 order, the backdrop to this litigation, my lord. 10/7/2024, there was an alarming increase in the deadly disease of dengue. And therefore, my lord, this PIL was registered as a suo motu PIL. In this way, I am saying this.
So they are releasing the amount, utilizing the amount.
Not everything I have met, my lord. What is raised in the petition, I have honestly placed it before my lord.
I'm not questioning on.
And I leave it to my lords.
We'll reserve the order.
Grateful.
Obliged.
Clean bench matters, seal number 10. Srimati Anuparna Burdalai. Seal number 10.
15th November.
Seal number 11. Ravina.
As although the prayer, my lord, is to actually consider a certain representation of us. I think this petition can be disposed of at the outset itself, my lord, because there's a revision petition of ours that is pending where an order of the state government, I'll take my lord through all the facts, but that revision petition, my lord, is numbered 74/22. My lords were to dispose of this petition, the direction of the divisional authority to consider our revision. But I'll just give my lords a brief background. In 2014, we had filed an application, my lords, for a quarry lease. Now, in the interregnum, in August 2016, certain amendments were carried out to the Karnataka minor mineral concession rules, by virtue of which all applications were rendered ineligible by virtue of the inserted Rule 8B1. Now, after the amendment was brought into force, the government issued an endorsement rejecting my application in light of Rule 8B1. We then approached this honorable court. This honorable court directed the authorities to once again consider. This was an order passed on 15th of September 2018. In short, what this honorable court said is this, that since it was incumbent on the state government to issue the NOCs, the government cannot hide behind the amendment to Rule 8B1. Now, subsequently, what happened, my lords? A couple of relevant facts. Rule 8B1 validity came to be upheld. Also, my lords, there was another litigation initiated by me where once again relying on Rule 8B1, that is in writ petition 1999, Once again, relying on the amended rule, my application came to be rejected. Subsequently, my lords may kindly see annexure G at page 47. At page 50 is the translated copy.
So you only want to decide the representation.
That also that it could also be disposed of, but possibly with an additional. I know that there is no such prayer, but there is a revision petition, my lord, which is pending since 2022. If the revisional authority could consider that, in light of, because right now what has happened is the rule itself has been amended. Let them get instructions.
Let them say what they want.
Certainly, certainly.
Sixth, without saying notice, you find out what is it. Sixth.
Grateful.
Sixth will be listed at 2:30.
Grateful.
So number 12.
I am for the petitioner, my lord. My lord, according to section 8 of MMDR, all the leases which are granted for mining, which have been extended for 50 years, my lord. My lease granted in the year 2006, it should be extended up to 2056, my lord. But in the meanwhile, I filed an application for a deemed extension. While considering the deemed extension application, the respondent has rejected my application on the ground that the land is less than 4 hectares, as per rule 22D, my lord. But 22D deals with only for the fresh leases, my lord. It is not for the extension, my lord. 22D, my lord, even that provision I have extracted in the petition itself, my lord. According to 22D-C, 4 hectares in respect of all mines deposits other than those specified under clause A and B. But there is a proviso, my lord, provided that in case of a renewal of a mining lease, the restrictions of a minimum area for grant of mining lease shall not be applicable. And in the same locality, my lord, the people who are having less than 4 hectares have been extended. Even that also I have annexed with the petition, my lord. At page 216, my lord. One applicant who was having 3.64 hectares and 220, my lord, which is 2.42 hectares, which is almost similar to the area which the petitioner is having. And there is one more, my lord, wherein it is only 1.19 hectares in 224, my lord.
Challenging annexure H.
J, my lord. Annexure J.
You are saying annexure H in the prayer.
Sorry, madam.
In the prayer, it is annexure H.
Okay, that the endorsement is given under H, my lord. The order is at annexure J, but the.
So where is the prayer to annexure J?
My lord, annexure H is wrongly mentioned, my lord. It should be annexure J.
Amend it.
Yes, my lord.
7th November.
The rate appeal matters, number 13.
My lords,
Nitin Prasad.
my lords, for the respondent, my lords, caveator, we have given issued NOC, my lords. The file has been collected by the parties.
So you are not appearing.
No, my lords, our name may be deleted, my lords, and matter may be heard on Monday, my lords.
The contesting respondent.
Learned so-and-so appears online. To state that the client have taken out the papers and the name may be deleted. Also, in that way, there shall be notice to the respondents.
But respondent is 1, 2, 3 government advocate, learned government advocate.
No, there is a government appeal, my lord.
You are appearing for whom, Mr.?
My lords, for the contesting respondent number 4, my lords.
Number 4. Therefore, there shall be notice to respondent 4. Returnable on 21st November.
Respond is 5 to 8, my lord, in the writ
Said
petition.
aspect and to enable the
Respond is 5 to 8, notice may be dispensed with.
make alternative arrange.
There's an appeal filed by the state government also, my lord.
This
There's an
serial
appeal
number.
filed by the state government that is listed at serial number 101, my lord, for the day. This may be tagged on along with that, my lord. Same impugned order, the state government has also challenged it.
Like this 21, which one?
For our writ appeal number 475 of
It may
2024,
also stand over to 21st.
at serial number 101.
November.
During a dispensation. My lord, your lordship may observe that the learned single judge notice response 4 to 8, 5 to 8. Notice was dispensed with accordingly, my lord. Here also they may be dispensed.
Not
Response 5 to 8, my lord.
Not necessary. Anything more? Yes.
14,
What is necessary? Yes.
14, 15 are urgent. Serial number 16.
My lord, I am for the respondent in this case, my lord. Serial number 13, my lord.
Yeah, 13 hoy. Now 14,
16.
16.
Not, there are 2 other writ appeals.
Yes.
There are 2 other writ appeals not arising out of the same order. One is filed not by the other batch of petitioners, and the other writ appeal not that may be listed along with this. Not.
So they are not. They are to be listed together.
Preferably not, so that not can be taken up together.
Yeah, there is a delay of 2 days.
Please not.
Delay of 2 days.
Yes.
Yeah, what is it about?
But the issue Lord relates to Lord a merger of 2 Lord government companies. Lord, the petitioners or the appellants were employees of a company called Lord OMPL. Lord, it was merged Lord with MRPL, which took over Lord by way of amalgamation order. The order of amalgamation, which is passed Lord by the first respondent Lord government, is to the effect that Lord the employees of Lord OMPL will no way be Lord in a lesser Lord capacity than they were earlier. Their pay, everything was to be protected. What Lord MRPL did was, after Lord the process of Lord amalgamation is going on, Lord, we also raise our objections before Lord the first respondent. And the first respondent Lord ultimately passed an order Lord of amalgamation. I'll just take Lord to that order. Lord, during the entire process, Lord, what MRPL does is it introduces a new grade Lord into Lord MRPL. And Lord brings us down on the scale as also Lord some of the petitioners Lord their salary is affected. The learned single judge Lord has Lord partially allowed the writ petition. Lord insofar as holding that the date to be taken into consideration Lord, for the purpose of Lord HR integration is a different date altogether. Lord subsequent development is Lord MRPL Lord issues a circular Lord calling upon all Lord these petitioners to Lord opt for 2 options.
This amalgamation was under the company that.
Yes, not by an order not passed by the first respondent government.
Everything else which is subject matter of prayer in the writ petition to have been taken care of by the amalgamation order only.
No, Lord. What happened? There are 2 things, Lord. What happened was, Lord, the HR integration is conducted by the second respondent, Lord, their employees, who themselves will be affected. It is judge of their own costs. That is why, Lord, our main grievance, what has happened is, people not who are employees of MRPA will also be affected not by this HR integration. So what is done is, I am being given a stepmotherly treatment, not bringing my ranks down below. And not some of the petitioners, their salary also affected. Mainly not with regard to gradation, what happens is, my experience is not considered.
My qualification is not considered. Earlier, my lord, right from my inception, my lord, I was established not by MRPL. And my lord, all my policies, my lord, are in tune with MRPL. And MRPL, my lord, they're also there.
On whose behalf?
I represent Union of India, 135 and 6. Respondent number 2 is the answering respondent.
But I'm told even not MRPL has filed an appeal.
They have filed a subsequent writ petition.
But what has happened is
not to be implemented. They filed another writ petition. Matter is pending before the learned single judge. Yes, permitted, my lord, us to, my lord, go ahead with this thing. We gave them two options, either, my lord, in terms of the order passed by a learned single judge or a better one. All of them have accepted the better ones. And that matter is pending before the learned single judge. This, my lord, what had happened was there was a merger of, my lord, the two companies. One of which is, my lord, these petition appellants before your lordships were, my lord, employees. They were, my lord, given salaries contrary to the ministry guidelines. In fact, my lord, there are CBC, my lord, has said, my lord, we'll have to recover monies from them. The accountant general, my lord, has said, my lord, there's excess payment made to them. In the merger, my lord, there was to be, my lord, normalization. We also challenge, my lord, that order before your lordships in another writ appeal, because that has not been listed. Okay. In the meanwhile, my lord, we gave them two options. In terms of the order passed by the learned single judge, or, my lord, a better option. They have all accepted the better option. That is also challenged by them, my lord, before the learned single judge. That is pending.
Lord, may I pass on, Lord, the interim order passed by the learned single judge, not a subsequent development. But the learned single judge says, Lord, that the order of amalgamation or not that not order provides that not I'll not be in any way, my lord, affected by virtue of this, my lord, amalgamation. But admittedly, my lord, the position is, my lord, they have taken a different date for the purpose of HR integration, which the learned single judge, my lord, has rejected their contention and said, my lord, the relevant date would be, my lord, 1/4/2021. Therefore, my lord, the entire thing has to be redone by them. And not our own main prayer would be, Lord, let it be done by an independent person. In fact, Lord, even if it is done by a retired judge of this honorable court, Lord, we are open for it, subject to what Lords would say. Because, Lord, otherwise it is goes back, Lord, to the respondent, Lord. They themselves will be affected, Lord, by the HR integration. But therefore, Lord, it is being a judge of their own cause. And, Lord, what they do is, Lord, one hand they challenge, Lord, the order of learned single judge. On the other hand, Lord, they issue a circular saying this is the implementation, Lord, of the order of the learned single judge.
And they accept it.
No, that is without prejudice, not as per the order, interim order granted by the learned single judge. Lords, may kindly permit me to pass on that order, Lords. Lord, my experience, my qualification, Lord, none of it is taken into account. But for the purpose of, Lord, the HR integration, Lord, what is the qualification? What is the experience? Lord, all those things have to be taken into account. But Lord, that is not considered. And Lord, more other important aspect is, after Lord, the orders passed by learned single judge, insofar as not the major chunk of not workmen of not these companies concerned, not the respondent not treats them at par with their workmen and enters into a memorandum of settlement. But for not the petitioners who herein not, who are not non-workmen or management staff, but they don't want to treat them at par. All the workmen not are treated at par not by virtue of a settlement now.
Workmen were not given not excess payment. These people were, I'll point out all that, CBC, the CAG, all of them have frowned upon what they are. Point out all that. Yes.
Yes, Lord. I'm not seeking for modification of the scheme at all, Lord. In fact, Lord, I am seeking for not, what happens is not after the order of amalgamation is passed, I am petition notice. But after the amalgamation order is passed, Lord, the respondents pass an order of Lord absorption letters, contrary to the order not of the first respondent. And that is the subject matter of the writ petition. Lord, I have accepted the amalgamation order, so has not the respondent company. Now, Lord, what they do is not kindly permit me to just not point out few facts, Lord. If my Lord, so please turn to
My lord,
the other two appeals are there.
2024, my lord. Writ appeal. Nine one three of 2020.
And 935 of 2024, my Lord.
Please.
Please, my Lord.
You want to modify the scheme of?
No, absolutely not, Lord. I am saying they have not complied with that order of amalgamation. That is my grievance. I am not challenging, Lord, scheme of amalgamation. Lord, I'm happy with it. But what I'm saying is, Lord, the respondent company, Lord, instead of complying with, Lord, the scheme of amalgamation, they do it contrary to that. That is my grievance.
Then that can become subject matter of writ jurisdiction.
Yes, Lord, because Lord, respondent, Lord, is a company, Lord, the Government of India undertaking. And that's the only, Lord, the...
No remedy under the company.
No remedy available, Lord.
Under the company.
No, Lord, it is not available. In fact, Lord, the Apex Court not had an occasion to deal with the similar issue because not Government of India undertakings, wherein not these matters, the issue, what has to be looked into is also considered by the Apex Court. I'll place that also, Lord, on record before Lords. Because my experience, Lord, my qualification, Lord, what has happened now is some of the petitioners not required to work under their juniors, Lord, who are working, Lord, in the respondent company. Earlier, Lord, employees of OMPL were transferred, Lord, to MRPL.
That is also not correct. I'll point out all that.
Oh, all right.
Please.
Lord, can I seek for a date, my Lord, subject to my Lord?
Date do you want?
Lord, 15th or 16th? Sorry.
16th is working?
16th is Saturday, my lord.
Sorry, 15th. Or Lord, 19th of Lord November?
19th.
Grateful. Can I also seek one more indulgence, Lord? If my Lord may permit Lord me to serve Lord, the council appearing for respondent number 2, so that Lord, the process is complete.
You can serve the copy, not
Lord, instead of 19th, can it be on 20th, my lord, if it's not inconvenient to my lords, my lord?
20th.
Grateful.
Grateful. My Lord, next matter, withdrawal.
Yes. This serial number 1, contempt 826 of 22, connected with the review petition 481 of 23.
Yes.
Yes.
And for the review petition, my lord. My lord, review is being sought under order 41 of 47, rule 1. Questioning the legality of this writ appeal number 310 of 2022, which was passed in on 8/8/2022. There is an Annexure A.
What was the earlier round? What was the earlier round where the court is recording that in the earlier round, the stand was taken that the stand was not taken that the petitioner was not against the sanction clause. What was that earlier round? In short, the stand is not justified that they were not appointed against this or that there is no sanction clause.
The respondents in this review petition are the daily wage employees. They are daily wages employees who doesn't fall within the framework of.
So what is the ground for review? Only that ground that they were
No,
not.
not only that. There is a per incurrium is there. Ignorance of the apex court judgment, per incurrium is there. Pending precedents of the Article 141 has not been followed, mistake of facts.
You can't re-argue.
I am not re-arguing as appeal. But it is my duty to submit before my lordship assisting. Starting with, my lord may please to see, refer to page number 57 of the imposed order, page number 57, internal page number 12, 57. My lord has got it.
It's a review petition. There is a delay of 1 year, 4 months. There's absolutely no explanation because control delay, number one. Number two, 1 year, 3 months. 3 months. Delay. Yes.
Delay.
Yes, yes. That too, knowing fully well the order in the contempt proceedings. 3 affidavits are filed, not accepted by the contempt court. Thereafter, we filed this review petition. Number one, delay cannot be controlled because 1 year, 4 months delay. Number two, his only ground is subsequently not judgment Supreme Court in 2017-3. My lord, he quotes it, my lord, page 19 of the grounds. In Rawat versus my lord Ashwini.
19th of?
Yes, page 19, page 20 he has quoted. The first ground is that. That's absolutely, not facts of those cases are, under the standing order, some orders are issued. Here, my lord, the Supreme Court has declared the law in 2006 in Umadevi versus the state of Karnataka Umadevi. My lord knows paragraph 54. But the regularization of this, my lord, petitioners is concerned, it has happened in 2001. My lord will find that in order itself of the, that is not on in the month of 24/4/2001. 24/4/2001. And benefit of regulation is not given. Court ordered, please give all the consequence benefits. Page 85, my lord, of the review petition. Kindly see. Page 85. Quoting Umadevi, state of Karnataka versus Umadevi. My lord. Para 10, page 82, my lord. Umadevi's case is called out. Then, my lord, para 85, this court said, bringing them under the purview of the act is bad.
please give them all benefits because their service are regularized on 24/4/2001. My lord knows in para 54 Uma Devi's case. Whatever regulation happened prior to that, not has to become final. It can't be reopened. It can't be reopened. No, this review petition is concerned, my lord. He can't re-argue the matter. Where is the error or the apparent error on the face of the record not to argue? He is re-arguing the case. Therefore, my submission to your lordship is delay cannot be controlled. Even delay control merit, he has no case at all. On the face.
Delay application is there?
Yes, my lord.
Delay application is there.
Yes.
I have filed on the suggestion by this on report, I have filed a better affidavit because I am before this on report all along.
Lord, one submission, Lord. One judgment of the late Supreme Court on delay, on 47 Rule 1, court officer. Good. Copy. Copy code of affidavit.
397 days.
This by Lord probably acquainted with this decision. Sanjay Kumar Agarwal's case, Lord, 2024 2 SCC. My Lord, para 16. A judgment, my Lord got it. Sanjay Kumar versus para 16. The gist of the absolute decision that a judgment is open to review, inter-alia, if there is a mistake, an error apparent on the face of the record. 2. Judgment pronounced by the court in final departure from that principle is justified only circumstantial, substantial and compelling character make it necessary to do so. An error which is not self-evident and has to be detected by process of reasoning, kindly similar, can hardly be said to be an error apparent on the face of the record, justifying the court to exercise jurisdiction. In exercise jurisdiction of 47 Rule 1, it is not permissible for erroneous decision to be reheard and corrected. A review petition as a limited purpose cannot be allowed to be an appeal in disguise. Under the guise of review petitioner cannot permit it to re-agitate, re-argue the question which have already been addressed and decided. An error on the face of the record must be such an error which mere looking at the record should strike and should not require no longer drawn process of reasoning on the points which were merely conceivably be to opinion. Even change in law, subsequent decision, that is 47 Rule 1 itself says, coordinate bench itself cannot be regarded as a ground for review. This is the principle laid down. Supreme Court said, Lord, review is not permissible otherwise. But where is the Lord? A striking error on the face in this case. May he rise of Rawat case subsequent decision. 47(1) Rule on itself says, Lord, the subsequent decision of the Lord coordinate bench cannot be the Lord reasons. We are bound by Lord Uma Devi 5 bench judgment, which said, Lord, the regulation which had taken place prior to Lord 2006 cannot be reopened. Therefore, my Lord, my submission to your Lordship is delay cannot be controlled. There is absolutely no case for reviewing this.
Where is your application for condonation of delay? What is the ground? What are the ground? IA 4 of IA 1 of 23.
23, thereafter I have filed a better.
Where is your affidavit? This is the only affidavit? Page 182.
Yes, my lord.
Yep.
Nothing is stated if this is the affidavit. Where is the accompanying affidavit? Spelling out the reasons for delay.
Yes.
Page 147. 147.
145.
147, if I'm correct.
7.
No, 182, my lord.
If 182 is the affidavit, there is nothing is stated.
No,
Yes.
kindly see application 145. 145.
There
Affidavit 147.
I was asked to file a better affidavit.
Ah,
I filed on 5th February 2024.
where is that?
Is there on record? 5th February 2024. Or dates of events in internal page number 4.
Affidavit not relies upon same Lord Naresh Rawat case page 6 para 6. Nothing else. No other reasons are there not even. But some of the respondents died, na? Some of the respondents have died. Some of them have retired. Wives are claiming pension. That is the stage, na?
So both IA and the review application. Our learned counsels for the respective parties reserved for judgment, reserved for orders.
Content is concerned, my lord, may.
Both.
Yes, great.
Both.
My lord,
Contempt is there.
Yes, my lord, is there.
Contempt is there.
Contempt is there. It's why, my lord, it is there.
Not contempt, why should come to this?
Because he filed a review petition, tagged along with this.
Filing 3 affidavits in contempt, he filed review.
Because he filed review after filing 3 affidavits in the content proceeding. They are not satisfied. Then file a review petition.
It is all right, but then contempt may not come before this bench.
Therefore, my lord may detag it, place before the appropriate bench for proceeding further. That's all.
my lord, in the meantime, I have filed the notes of arguments for the review petition, 620 pages. Complete notes of arguments, how they are error upon to the face of it.
In contempt petition, these petitions will be placed before the
Review petition, I have filed.
appropriate bench,
No one can be.
taking up such matters as per the roster. Done. For the rest, separate order, reserved.
And there is a one more submission. I will take another 1 minute. Page number 55, the review petition.
55.
55 of the review petition, ink page.
Respondents ಎಲ್ಲ ಮಿಸ್ಟೇಕ್ ಏನು
55 RP. In RP. Review petition, inter page number 11 of the import order.
Post title.
Cost rate.
Post title.
Cost, starting from cost rate. How there are, I know the limitation of the review petition. I am not re-arguing, but error apparent to the face of it, can we allow it to be continued? I am submitting. Page number 11. Respond number 43 is the government.
Page number 11.
11. Inter page number 11. State of Karnataka, represented by Secretary. 44, Chairman of the silk board. Page number 12. Respondent number 45 was Commissioner Sericulture. Now, in the same page, pair number 2, the respondents are daily wage employees. Can we call this 43 to 45 as daily wage employees?
So who are they? Who are they?
These government,
There are 2 to 43 are daily employees.
not only one place, it is a 3-4 places.
It's a state appeal, not filed by us.
Error upon the face of it.
You thought we are making very serious argument.
Even we were not
This is not a
allowed to
case
be there in the court hall
We'll consider.
when the order was passed.
of-
That is the reason this.
application on the important ಇದೆ ಇದನ್ನೇ ಕೊಡಿಸ್ತಾರೆ ಅವರು. ವಿಡಿಯೋ ಮಾಡಿ ವಿಡಿಯೋ ಬರ್ತಾ ಇಲ್ಲ.
Let's turn to page number 43, my lord, I have challenged annexure N. Page number 125, my lord, wherein why recognition granted to the petitioner institution should not be withdrawn, my lord. The petition came to be dismissed.
Not paging, I am not able to. Page.
Page number, my lord, 125, my lord. Right. Typed copy 127. Translation at page number 132.
Dating time. Posted
Right. Page number 138, my lord, operative portion. A deputy director Mysore notice to the school instructed to submit proposal recommendation to withdraw the recognition. This was challenged by my lord. Writ petition came to be dismissed and writ appeal was filed, my lord. During the course of hearing, my lord, the respondent submitted that they have permitted the student to take up SSLC exam, my lord. And in the open court, my lord, they have issued the order withdrawing the recognition order, my lord. The lordship has granted liberty to challenge that order, my lord. Only clarification is there, my lord, in the open court, my lord. They have produced the order of recognition, withdrawal of recognition, my lord.
Petition is disposed of.
Writ petition was dismissed, my lord, against which writ appeal is filed.
You want to revive and challenge?
Not revive, my lord. During the course of admission, my lord, the respondent government advocate has produced the order withdrawing the recognition, my lord. The your lordship permitted me to challenge that order, my lord. That portion was.
All right, which petition is pending?
Now the writ petition is not pending.
This is what we are asking. If it is not pending, then how can you challenge?
My lord, writ petition was dismissed against which writ appeal is filed. In the writ appeal, my lord,
Want to revive the writ petition?
not revive, my lord. They have produced the order in the open court, withdrawing the recognition order, my lord. That your lordship permitted me to challenge by filing separate writ petition, my lord.
Oh, then
That portion of the order was not forthcoming in the order, my lord. Therefore, I sought for clarification, my lord.
you file a separate petition.
Yes, my lord, I have filed separate petition. Their lordship dismissed that writ petition to challenge that order produced before the sum court in the open court, my lord. Therefore, my lord, I have sought for clarification, my lord.
So which is that writ petition? That is what we are asking. Is it 7545? 7545?
Yes, my lord. 7545 of 2024.
That is pending?
No, my lord, that is disposed of granting liberty to get clarification, then move the court.
Where is that order?
That I have not. It appears 75754. 7544.
7545 of 2024 is still pending, my lord. There they have raised the objection.
It is to be granted, brother?
It can be granted, my lord.
Granted.
That writ petition, they are challenging the order of derecognition dated.
So they indirectly reviving the petition.
Yes. That 7545 is still pending, where the government has raised the objection.
7545 is pending?
No, my lord, disposed of to move the revive the writ petition after getting liberty to
is there,
challenge.
my lord, with them. If 7545 is disposed of, my lord, that liberty has been granted by the learned single judge asking him to.
In that order, liberty is granted.
No, that's what my learned friend.
Liberty was granted.
Yes, you want to say where is
Can
that?
give the liberty, my lord. Let them challenge that order of derecognition dated.
Where is that liberty?
My lord, that I have not produced that.
Pass over the order.
That time.
Order granting liberty to challenge is, where is that? Then we'll allow immediately. You are saying that in the order of 4565, liberty is granted.
Yes, my lord.
Where is that order? That's a short thing.
Where 4 of the affidavit, my lord.
Perusal of the
Private
audit
file
and would indicate that the coordinate bench has considered all aspects as to whether there are students in the school studying or not. Coordinate bench has come to a conclusion. There are no students and has been dismissed the petition. This aspect has attained finality in my
Para 5, my lord.
opinion.
This aspect having attained finality in my considered view cannot be opened. The present more so when a writ appeal challenging the said state learner council for the petitioner seeks permission to move the division seeking clarification, and the petitioner always would have that liberty. No grounds have been made out. The present petition is dismissed. But unless that permission is granted to challenge that order produced before the sum court, my lord, in the open court, withdrawing the recognition order, my lord.
No, I am not able to understand. Adjourn to. Unless you explain to me, I am satisfied, we will not grant.
My lord, in the open court, my lord,
What, you want to revive some petition, will not permit.
Not revive, my lord.
Then
They have
where is that liberty to challenge the order?
My lord, the writ appeal, my lord, when this writ appeal was posted before the Sam Court, my lord, the government advocate has produced the order withdrawing the recognition of the institution, my lord. That your lordship granted me permission, liberty to challenge that order, my lord.
There is no liberty I am finding.
That
We'll consider. Unless I am convinced, we will not pass.
please, please.
Yes. So let it go to, let it be listed on, brother, 14th, this 14th
Yes,
November would do?
Yes, Chief.
14th November,
Yes, Chief.
14th. November.
Please.
Yeah.
Pass over matter, seal number 7 to Jagdish Dr. 7, contempt.
None was present on behalf of the petitioner in the first session. When the petitioner was called out, full stop. In the second session also, the contempt petition was called out for the second time. Nobody remained present. No request was made. No mention was advanced. Could have been dismissed for want of prosecution or in larger interest of justice, send out 22nd November.
Yes. For settlement, seal number 122, 122.
I'm for the rest.
Appellant for appellant minutes. Once parties have decided to amicably settle the matter, appellant is paying for an amount of 5,06,000 through DD.
What is this 2 lakhs amount? Amount of 2 lakhs is what?
It has been deposited in favor of Registrar Melons, Registrar General, in compliance with interim order Melons. Interim order.
Pursuant to the order, directions given by this honorable court.
So who is present?
Both the parties are present.
This appellant defendant is represented by whom?
Appellant is represented by its accounts manager, my lords. He has been authorized in the recent board resolution. It has been
Where is the name mentioned?
Manoj Jain, my lords. The board resolution has been produced along with the compromise petition. The previous authorized signatory have left the firm.
They all right, but his name is not mentioned in the course title.
My lords, the board resolution have been produced along with the compromise petition today. Board resolution was dated 9th October 2024, my lords.
The present commercial appeal arose from judgment and decree dated 28 November 2023, passed by learned (82nd) 82nd additional city civil and sessions, Bengaluru. In commercial original suit number 471 of 21. The suit of the plaintiff
472 of
came to be decreed. And the defendant, as the appellant herein, was required to pay the amount of rupees. Where is the decree? Amount of rupees 3,87,736.55 with interest at 10% from the date of filing of the suit till the date of realization. Paragraph. When the appeal came up for consideration today, learned advocate for the appellant original defendant, Mr. So and so, jointly with learned advocate, Mr. So and so for the respondent original plaintiff, jointly submitted, now jointly, not earlier, memorandum of compromise, stating before the court that the parties have settled the dispute outside the court. The appellant defendant has agreed to pay rupees 5,06,000 to the plaintiff in full and final settlement of the decree, and that the plaintiff has agreed to accept the said amount. It is stated that the demand draft number 406729 dated 24/9/24 for the said amount of rupees 5,06,000 is already handed over.
Just now.
Is being handed over to learned advocate for the
Respondent, myself Tushar.
respondent. The check is handed over in the open court and is transmitted to the plaintiff. DD, full stop. The compromise, memorandum of compromise also accompanies affidavit of one Sri Pradeep, son of Parsar Tiar, who is the partner of the respondent as plaintiff firm. Also filed an affidavit by Sri Manoj, son of Narayan Swami, who is the account manager of the appellant company as the original defendant. And as per the board resolution dated 9/10/24, he is authorized to represent the appellant company in the present proceedings and to settle the present proceedings to represent the company. Paragraph. The parties above named representing the appellant defendant and respondent plaintiff are personally present before the court. They were identified by their respective learned advocates. Yes, what is your name?
Pradeep Parthasarathi.
What compromise you had done?
What was the amount given, my lawyer? 5,000, 5,06,000.
5,000?
5,06,000.
5,06,000. You satisfied?
Yes.
So willingly done?
Yeah, willing done. Yeah.
You know what is the settlement?
Yes.
What is the settlement?
5 lakhs.
Instead of,
Of the outstanding.
what was the decree passed against you?
3 lakhs.
The parties, when asked by the court, stated that they have entered into the settlement out of their own volition. Uninfluenced by any external aspect. Full stop. In view of the above, the settlement is accepted. The judgment and decree dated so and so substituted by the term of settlement. Full stop. The appeal proceedings are closed in view of the settlement.
As the court fees and the deposited amount may be returned.
Full stop. At this stage, it was pointed out that at this stage it is pointed out, where is the settlement? At this stage it is pointed out that by interim order dated 21/2/24 and 3/4/24, this court had directed the appellant to deposit ₹2 lakhs, which was deposited as per demand draft bearing number 443608 dated 4/4/24, which may be returned to the appellant. Full stop. Since the parties have settled the dispute in terms of above compromise deed, the said amount deserves to be returned to the appellant. The registry is directed to return the said amount of ₹2 lakh to the appellant hearing after undergoing the necessary procedure, including of identification. Paragraph. Learned advocate for the appellant further submitted that as the appeal is disposed of without any effective hearing, the court came out of ₹34,464 paid while filing the appeal may be refunded. The registry is directed to refund the amount.
My lords, while dictating, commercial OS number 471 have been dictated instead of 472, my lords. Commercial OS number have been dictated as 471, my lords, instead of 472. It must be 472 of
Is correct.
2021.
471.
472 of 2021, my lords.
472 is correct.
Yes, ma'am.
470. Appeal is disposed of by the court.
Serial number 123. Shivacharana.
Appearing for the appellant, my lords. We have filed a memo for withdrawal.
In view of the memo dated 19/24, seeking withdrawal of the appeal. Permission is granted to withdraw the appeal. It is dismissed as withdrawn.
Hundred and 24. Mr. Biradar Sharanappa.
This is coming for the first time.
Yes, my lord.
What is the direction? Let us.
It's a contempt petition, my lord. Learned single judge of this honorable High Court was pleased to pass the order on 5/9/2023 in writ petition number 33934 of 2011. And it has become final, my lord. Order has become final.
Correct. Where is the direction?
Direction is at the para 15, my lord, or page 15, my lords.
Page 15.
Yes,
Read
my
it,
lord.
read it.
Para 7, my lord, page 14, so apology, my lord. Page 14, para 7.
Read it.
However, as observed by the government, respondent number 4 institution would be under a legal obligation to pay the salaries that the petitioner is entitled to as per the terms of appointment. So petitioner put in 24 years of service,
Where is the time limit fixed?
my lords.
Where is the time limit fixed for payment of salary?
Even then, my lords, my sincere submission, my
The
lord,
direction in this contempt, which is,
my lords, one,
kindly listen, direction in this contempt petition issued by learned single judge is about is that the petition number, respondent number 4 institution would be under legal obligation to pay salaries to the petitioner as per the terms of appointment. Full stop. On a bare reading of the aforesaid contemplation found in paragraph 7 of the order would indicate that no time limit is fixed for compliance of the direction about payment of salary. When there is no time limit prescribed by the learned single judge, it could hardly be said that any of the respondents has at this stage committed any contempt, much less willful contempt of the court. Therefore, the filing of the contempt petition is not well conceived. Paragraph. However, at the same time, the order of the court should not go uncomplied with. Therefore, it is provided that unless the respondent, unless the competent authority of the respondents comply with the direction in paragraph 7 of the order dated 5th September 23 in the writ petition number 3393/24 within 12 weeks from today, the respondent shall be exposed to aggravated contempt, disposed of accordingly.
much obliged, my lord.
Number 125, K.R. Lingaraj.
In this case, a bit appear for complaint, my lord. Direction of this court, my lord, in writ petition, my lord, page number 8, my lord. Relevant portion is page 10, para 4. The Tahsildar is therefore directed to place the application of the petitioner before the committee along with the recommendation within a.
We have filed the affidavit, my lords,
That is that.
and the similar matters have been disposed of
My-
and placed the judgment
That
of
is your affidavit.
affidavit, my lords, is
Yes.
filed on 23rd April 2020.
My respectful submission, my lord. Tahsildar is directed to place the application before the committee. My lord, without placing application before the committee, my lord, straight away the Tahsildar rejected the request, my lord. It's a clear violation of the order of this court, my lord. The committee has to decide my application. Without placing there, my lord, the Tahsildar himself.
So it is not dealt with by committee.
It was not placed, my lords. The act provides that. The statutory act, my lords, it says that when there is no land available, my lords, it is classified as ineligible application and it will be directly placed before the deputy commissioner. But similar cases have been considered by this honorable court, my lords. I have produced the judgment in the last date of hearing.
You did this order to your friend.
My lord, insofar as, my lord, the Tahsildar, my lord, cannot decide my possession.
Kindly look at this order, passed in the similar facts of the case. We can't change our view, which is very correct.
My lord, now the Tahsildar, my lord, saying that I am not in possession, that's incorrect. The committee has to verify my application. The committee has to examine whether I am in possession or not. The committee has to take decision. Even direction is also, the learned single judge just directed the
Tahsildar to place before committee. Here, Tahsildar had a first order, my lord. You have no jurisdiction to decide my possession, decide my application. It is a Gomala land. Since immortal, my father, then me, the revenue records are specifically shows that I am in possession. The column number 12 of the RTC shows that I am in possession. Here, Tahsildar, he passed a vague order saying that he was not in, he is not in possession. And he was not also authority to take such a decision. The committee has to examine. The committee has to go to the spot, verify the revenue entries. They can't throw away the.
Writ petition was filed seeking direction against the respondent to constitute a committee and regularize the unauthorized cultivation of the petitioner in the land. The petitioner was disposed of, requiring the authority to place the application before the committee, along with the recommendation within stipulated time. In the present contempt proceedings, the non-compliance of the breach of the above direction is complained of. While learned Advocate Pereira for the petitioner complainant would submit that the application of petitioner was required to be placed before the committee, along with the recommendation from a learned additional government advocates in the Pramodinication relied on order of this court in Ravi Kumar H versus the Amrut Authorized CH-1 in contempt. Petition number was 713 of 2024. The said contempt petition arose in light of the identical direction requiring the authority to place the application before the committee for regularization. Full stop. Court observed that the deputy commissioner find the application to be not find the application to be not eligible. Therefore, there was no question of placing same before the committee. Full stop. In the present case also, when the compliance affidavit is seen, it is clearly stated that the Deputy Commissioner Mandya, as per amended rule number 8108 CC of Karnataka Land Revenue Rules, Land Rules 1966, passed order dated 10/4/24 by rejecting the application of the complainant. An endorsement dated 12/4/2024 is received accordingly. In that view, there was no requirement there was no question of placing the application before the committee concerned, as it was found to be ineligible. Full stop. Paragraph. The order in Ravi Kumar H would apply to the facts of the case. The respondents have acted in accordance with law. No contempt would be said to have been committed. The present contempt petition is dismissed.
With liberty, my lord.
What liberty?
In para number 5 of the order, my lord. Liberty to challenge the order of Deputy Commissioner as well as Tahsildar, my lord.
At this stage, learned advocate for the petitioner submitted that the liberty may be reserved for the petitioner to challenge the order of the Deputy Commissioner, whereby the application of the petitioner is treated and ineligible. Such liberty is reserved
As well as
to be availed in accordance with law and on its own merits.
As well as Tahsildar, both orders are there. Deputy Commissioner as well as Tahsildar.
As well as Tahsildar.
Please, my lord, much obliged.
Number 126.
Court, however, has not expressed any opinion, does not express any opinion on in respect of such recourse.
126, Mr.
I appear for the petitioner.
My lord, before my learned senior can begin, my lord, and I pray for some time to file my objections, my lord. It came up for the first time on 26 September 2024.
Thereafter, it was adjourned thrice. I have been mentioning, making a request for interim order. It is based on, my lord, the provision of law itself. Let them file their statement. But in the meantime, the impugned order may be stayed. I will narrate the facts, my lord, within a small
Lord, I
compass.
oppose any interim order. My lord may grant me some time.
Lord, this is more than a month. Statute itself clearly says I have got a right to go on 8B2. And they pass an order contrary to that, my lord, unamended provision. Section 8B2, my lord, originally said, Lord, the short facts, if your lordship permits me, I will mention them. To seek an interim order at the hands of this honorable court.
It is about, forest clear.
Yes, my lord, and they haven't paid, my lord, the lease from whom they have taken a transfer. My lord, those less than my lord and the net present value.
They have purchased in auction.
Yes, it was purchased in auction. My lord, this is a very delicate issue. My lord, if my lord could grant me 2 weeks' time, my lord, I'll file my statement and convince my lord. But the question of stoppage, staying the stoppage notice doesn't arise. My lord may see the date on which the notice is issued, the date on which the writ petition is filed, my lord, and the hurry with which now they are forcing the government to see that, my lord, the statement is filed. In April 2024, my lord, the notice is issued. My lord, the writ petition is filed on 17 September 2024.
Notice is issued when?
My lord, it's
September,
September.
20th of September. Thereafter, it came twice, my lord.
My lord, the
And then I
notice
made
is
a
dated
mention.
8/4/2024. Writ petition is filed on 17.
My submission.
No, it's all right, sir. It's all right. I'm not.
I will leave it to my friend if she wants to say.
I will respond. What
I'm
has
just
happened in
seeking
this case?
time.
What has happened in this case is, originally a lease was granted in favor of RO Minerals. Pursuant to its expiry, my lord, there was an auction as per the MMDR Act. I was the highest bidder, having paid nearly 5 crores of rupees to the state government. I have been recognized as, my lord, a preferred bidder. I have got environmental clearance and everything I have taken. My lord, section 8B2, prior to, my lord, the holding of auction, if your lordship would kindly turn to section 8B2 of the MMDR Act. It said all the, my lord, 8B2. There is 2 years. 8B2, no? 8B1. Yes. 8B1, my lord.
Ready to stop at notice page.
My lord, annexure N.
My apology for interruption. That was issued based on a pre-amended 8B, my lord, which originally said 2 years. Now it, my lord, 8B2 says till the expiry of my lease.
My lord, page 176.
Impugned order. Yes, yes. 8B1. There to 8B2. Yes. Yes.
So the ground appears to be that maximum period of 2 years is over.
Yes. The earlier lessee should have had a valid right, which the earlier lessee did not have. Because they did not pay the compensatory afforestation, my lord, which comes up to nearly 7 crores. My lord, I'll file my statement, my lord, and I just require some time. My lord may see the condition working permission, which is at page 157. My lord gets it at page 158.
File it for 6th of August, 6th of November.
My lord, in between there are holidays, my lord. I won't be able to meet the officers.
So then
My lord, I brought this to the notice of my lord. My lord, it's 8th April there, the notice is issued. 17th September, they filed the writ petition. My lord, the writ petition comes up on 26th. My lord, sometime, my lord, I'm not going to ask for. In between, there are holidays, otherwise I wouldn't have this thing, my lord.
Lord,
My lord may have this
8th.
11th, my lord. 11th or 12th, my lord, may have this on 12th.
may I make one respectful submission. Whatever my friend is saying about the previous lessee is not at all there in annexure N. The only reason they stopped is
2 years period has expired. My lord, even before the notification calling for tenders, accepting me as a highest bidder, executing a lease deed in my favor, all this happened after that 8B2 was amended to remove the 2 years. Now, my lord, they go back on the old unamended provision and say you stop work. She is inventing reasons now to say my predecessor has not paid. I'm sorry to say this.
You may be right on merits, we do not know, but we are not going to pass an interim order. And we'll hear the petition only finally, once they file reply. The reason is that any interim order will be granting the main relief.
Yes, my lord.
Therefore, we will not grant an interim relief.
My lord, there is a statutory right in my favor. My lord.
We'll hear the entire petition.
Because I have been stopped. The reason is, my lord, if I do not produce within a particular year so much of material, I'll be mulcted with heavy penalty, my lord, under the rules. And if they stop me like this, contrary to the provisions of the Act itself, my lord.
So we'll consider, not that we are not saying that you are wrong or right. Interim order.
No, my
is
lord,
not-
till they file, at least your lordship may grant me an interim order, my lord. Because otherwise, my lord, question of grant of interim order does not arise in any case. This is a classic case where, my lord, they rely on an unamended provision and apply it to, my lord, a situation where the provision is itself substituted. 8B2, your lordship may kindly see. 8B2, my lord, sorry if I am taking your lordship's time. My lord, unamended in 2021 was 2 years.
Grant him time. If you want the reasons to be recorded, we'll record the reasons for not granting interim.
He is already concluded. What is the Lord, all that I can say is 8B2 is, my lord, how can the government go on like this, my lord? I leave it to your lordships. 8B1 earlier said, my lord, 2 years. I have deposited 5 crores. Now, my lord, 8B2 says.
Shall we grant the time to the government advocate straightway or after recording your submission and rejecting it?
We will have it any day that is convenient to the court as well as to the government advocate.
Okay.
My client only will suffer till
For
then.
fixed time to file reply. To submit that the 2 weeks time may be granted. Full stop. It was noticed that the request for time is forthcoming for the second time.
Yes, my lord.
Third time, my lord.
My lord, it's
time.
26/9 and now it's coming up today. I'm making a submission to my
This is
lord.
the kind of argument I have no answer, my lord.
Not
I can only meet with an argument which is in
my
accordance
lord,
with
I
law.
don't unnecessarily
For
move
the
for
third
time.
Considering the side aspect, paragraph. No time could be granted to learned additional government leader except up to 7th.
My lord,
except
12th,
up to
my
7th.
lord, my lord, 12th. My lord, I won't get the officers, my lord, 12th, my lord. I'm not seeking for a long adjournment, just 12th.
Except up to 11th of,
Very
2:30, my lord.
we'll take up.
obliged.
Remind us on that, we'll take. But serve the copy in advance.
Yes, yes. Obliged.
Should I remind in the morning session itself or?
Please, do it. To your colleague, you do it.
Yes. Great.
Seal number 127 to Narsim Raju.
Page 99, there was a court order, my lord.
Against an interim order, my lord, appeal is filed.
99, earlier, they tried to transfer me, my lord, government, from the post of SLAO2. This honorable court, kindly see page 99 for a moment. This honorable court said, at direction 3 and 4, consequently orders, notification stand quashed, petitioner shall continue to work as Special Land Acquisition Officer to Karnataka Industrial Areas Development Board. After this order is passed, the government used its power under section 19 to remove section 17 of the KDB Act, which is power to issue general directions.
Learned single judge, my lord, says that section 17 has to be considered, but then does not grant the interim order. It was granted, it was vacated.
What is the controversy?
The controversy is that I was appointed SLAO 2, my lord. Then they made a premature transfer. Page 99, I challenged that
Then
premature.
learned single judge vacated the interim order.
He vacated the interim order, but learned single judge says that section 17 has to be considered. Whether there is a, section 17 is a power to issue directions of a general
Vacated
nature.
after reading both the sides.
Yes.
Yes. Power to issue directions of a general nature. Learned single judge says, yes, we have to consider section 17. It's an important issue, but the interim order is vacated, asking them to file their pleadings. And Lord, so far as violation of this honorable court's order, because this was an indirect attempt to get over the directions of this court. Kindly see page 99.
Our objections are also ready, Manoj. We can file it. If my learned friend is ready in the main matter, Manoj, the learned single judge can.
But the controversy has to be alive, Lord.
What is section 17?
17 is power to issue directions of a general nature, which the act confers upon the government and direct the KIDB to take further action. Whether under powers of general directions of a general nature, they could change the zones of the special land acquisition officer. That is a question. Remove him from one zone, put him into another zone, whether they could do that.
You
That
want
was-
to convert us into learn a single judge? We'll ask the learner single judge to dispose of the petition.
Not one issue. One is, if the stay is vacated, the controversy is not there at all. The controversy has to be kept alive, not. Otherwise, if the stay is vacated, I am removed from that position. Then I will be arguing from a.
You can be taken back if you succeed.
It will be-
Petition is pending at last.
Court says that the 17 has to be considered. If it has to be considered, Lord, then
So that will be
controversy has to be kept. This is one. Second, Lord, kindly see page 99. Page 99. This honorable court, when I got the previous transfer struck down, this honorable court said at direction 3 and 4.
This is in some other matter,
Yes,
same matter.
same matter earlier round when they tried to transfer me. It said consequentially order, the direction 3 and 4. Lord. Consequentially order stand quashed. That is the transfer order. Then 4 petitioners shall continue to work as special land acquisition officer 2. Karnataka Industrial Areas Development Board. Now, since there was an embargo. Since there was an embargo, they could not get over this, the order of this honorable court. So therefore, Lord, they use section 17 power.
Having heard learned advocate Mr. Vivek Subba ready for the appellant and learned advocate general Mr. Sashikara Sakti assisted by learned advocate. So the respondent, the court could immediately notice that the order brought under the appellate jurisdiction dated 15/10/24 passed by learned single judge is an interim order. Paragraph by the said order, interim relief earlier granted in the proceedings of the writ petition came to be vacated after hearing both the sides. Full stop. Since the order is interim order, by very nature, it doesn't determine the rights of the parties finally. Also, the entire controversy raised in the petition is at large whole on a single judge to be considered on merits. Therefore, while not exercising the appellate jurisdiction, the court finds it in the fitness of things to request the learned single judge to dispose of the writ petition as early as possible, preferably within
2 weeks, 1 week or 2 weeks. Otherwise, Lord, there's no point in.
Leave it to your lordship.
prefer 6 weeks.
Very well, Lord. But at least can I seek a
Appeal is
status quo till then, Lord?
Appeal is disposed of accordingly.
Status quo ante till
The
then.
court did not express any opinion on the merits of the case of the either side. Full stop. It is further clarified that the observations made and the view taken by learned single judge while passing the interim order shall not influence
Please.
the final consideration of the matter.
But can it be 4 weeks? 4 weeks, because pleadings are complete. 4 weeks, please.
4 weeks since pleadings are complete.
Number 17. Udita Ramesh.
Appearing for appellant in this matter. My lords, I may be permitted to withdraw the writ appeal.
What is this? It is
I'm
same, the same matter which was resolved. What are you asking?
I'm asking for withdrawal of the writ appeal, my lords.
Withdrawal of the return.
Finally, it was heard and that was reserved.
Earlier,
The order was not signed. Not signed. Learned advocate with the appellant files memo dated 28/10/24, which reads as under import this. Full stop. As per the memo, permission is paid for to withdraw the appeal and to further prosecute OS number 154/2014. Full stop. Permission is paid for is granted. The writ appeal stands dismissed as withdrawn. It is observed that OS number 154/24 may proceed to be decided on its own merits.
much obliged.
This is number 18. Srimati Vaishali Hegde.
This was which.
This matter, my lords, wherein the provisions, my lords, relating to grant of grace marks was challenged. Insofar as, my lords, the first year MBBS exam. Now, my lords, there was an interim order granted during the pendency of the writ petition where we are permitted to obtain the classes. My lords, the issue was whether the 2019 guidelines, regulations of NMC would be applicable to us, or whether the guidelines of 2023 would be applicable to us, which there was a vast difference between the regulations of 2019 and guidelines of 2023. Our case was, since we were admitted in 2022, prior to the guidelines coming into force, the regulations which provided for awarding of grace marks should be applicable to us. That's
The contention was that when you entered the course,
yes, my lords.
the
And
guidelines which were prevalent,
regulations.
and they would apply.
Yes, that would have.
So see 1984 Supreme Court 1514.
Now, my lords,
Mysore University or what? Punjab University.
lords,
Identical.
and also, my lords, whether
84 Supreme.
my lords, I am aware of that. My lords, the other position was whether guidelines will supersede the regulations, which have a superior efficacy. Now that, my lords, is on the merits. But during the pendency, we were allowed to attend the classes of second year. Now, my lords, I also took up the examinations with the permission of the court for a regular exam, and I passed the first year exam without any grace marks also. Ultimately, my lords, I have attended second year. I have also attended the internal exams. Now, my lords, the final exams will
So there is no need for you to take advantage of the.
the supplementary, now the grace marks issue has gone, but the only issue is now the writ petition is dismissed. So whatever benefit of attending the classes of second year, my lords, that has now been wiped off. Now, though I have passed the first year, I have attended second year internals have passed. Now the final exams are due for the second year exams. Now, my lords, I'll have to go back again and join with my juniors next year for the second year. That's the issue, my lords. Even if that equity could have been balanced is my humble submission. Since I have already passed on a regular basis without even grace marks on one subject. Without grace marks, I have produced the marks card. During the pendency of the writ, we were allowed to take the exam also.
So controversy in the main petition became infectious.
Virtually became infectious, but we had to had the benefit of that continuing in the second year. Otherwise, now I'll have to join next year for the second year with my juniors.
Or who appears?
My lords, Rajiv Gandhi University and
Miss Farah Fatima would, she appeared for the university in
You notice,
minutes for the university.
please you notice.
Please.
Or learned senior.
Earliest. Notes, I'm told 7th November is the last day to pay the fee. At least let me be permitted to pay the examination fee. That's for the second year minutes. I produced the notification.
Submitted that even as the writ petition is dismissed as per the being judgment in order. The original petitioners have attended the classes for second MBBS.
Second year MBBS.
Second MBBS. And have pursued the studies in regular course.
Yes.
It was submitted that the said
We have also taken up 3 internal exams.
pursued to the course may not be wiped out only because writ petition came to be subsequently dismissed. It was submitted that the which examinations are due.
That's the second year MBBS exams.
Second year MBBS examination is due when?
Theory exams.
7th.
No, the fee, payment of fees, my lords, is 7/11.
Payment of, then
Payment of, the examination, my lords, is scheduled to be held on, my lords, I'll just submit the date of examination is, my lords,
the last day for payment of fee is 7th.
7th, my lords. From 2nd of December it starts,
Then it's a
the examination.
Notice written on 4th
Please,
of November to be listed at 2/3.
please.
Should be open for the council for the listeners to
Appellant, this,
copy of the learned advocates who appeared in the writ petition.
please,
In addition to
regular
mode of service to the respondents.
oblige.
So no relief at this day. We'll see on that day.
Please.
Yes. Bill number 19. Ajay Jayan.
Lord, a demand for excise duty, state excise, has been issued without any notice, without any assessment order. Identical issue, my lord, had come up for an earlier period, and the learned judge, my lord, had allowed the writ petition. On the submission made by the government that this deputy commissioner who has issued it has no jurisdiction. In this case, my lord, the audit department raised an objection based, my lord, on a best judgment assessment basis. We have submitted our response. No notice, no adjudication. Please see the demand, my lord, at page 93. No order at all.
Page 93.
93, my lord, is the demand straightaway issued by the Deputy Commissioner of Excise.
But then interim order is in your favor.
My only submission is this, my lord, 25% have been asked to deposit. This exactly identical issue, my lord, on the earlier occasion, this honorable court, my lord, when the same thing was raised for 15-16, they made a submission to say he has no jurisdiction, will withdraw the notice. And that is recorded in the writ petition is disposed of. I have a copy of that order, my lord. The department accepts that. And subsequently, my lord, what happened?
Because appeal must be available against this demand notice.
No, there is no appeal. There's no adjudication. My lord, what happened was the audit department, my lord, they raised a question to say that the amount of malt that you took is not commensurate to the beer you produced. Exactly identical issue, my lord. The deputy commissioner issues a notice. In an earlier occasion, matter comes before this honorable court. The department comes and says they'll withdraw the demand. Then, my lord, that writ petition is allowed. The demand is set aside. Then, my lord, the adjudicating authority, who is the commissioner, adjudicates it. He passes an order that comes before this honorable court. This honorable court says what you have done is wrong and quashes the demand. I have it.
So where is the demand notice?
The demand, my lord, is annexure A at page 93.
That is only audit description.
What they did, my lord, was CAG audit, my lord, raised some audit paras. We raised, we gave our submissions also.
So therefore,
After that, no order, no adjudication.
but at page 93, where is the effective demand?
That is the demand, on page 93.
Directed to pay, yes.
Yes, directed to pay. That is what is included in the writ petition, my lord. Total of this comes to 27 crores.
Third learned senior advocate, Mr. Nagananda, for the petition. The writ appeal is the appeal is directed against order dated 1st October 24, passed by learned single. In the original petition, demand notice dated 17/8/24 was under challenge. Full stop. A copy of said notice, figures on record into bracket annex array, page 93. Full stop. It gives details of certain audit paras as under. So it is 1, 2 on page 3, 4, 5. Yeah. Quote from page 93. Full stop. On the page of the aforesaid audit observation, the Deputy Commissioner of Excise, Mysuru Rural District, Mysuru, has straight away directed the petitioner to pay the said balance amount. Full stop. The submission paragraph on part of learned senior advocate for the petitioner that the demand of the said amount is without adjudication, and just on the base of the observation of the audit department, is of substance, full stop. In the aforesaid view, even though the order of learned single judge is interim order whereby the petitioner is directed to deposit 25% of the demanded amount, could be well said that the order has the trapping of finality inasmuch as 25% amount is demanded, which too is without adjudication. Notice returnable on 20th November, the part of the direction of learned single judge requiring the petitioner to deposit 25% of the demanded amount shall remain stayed till the next fifth.
Still number 20.
Could it be anything?
22nd, 23rd, I have some personal link.
Whenever you,
24th or 25th.
25th.
Great.
20, still number 20.
Here for the complaint.
Your Worship, we're pleased to hear this matter, Manoj. I had sought time on the last occasion, Manoj, after the matter was argued. This is pertaining to election, holding of election to Mysore Chamraj Nagar. Manoj.
I appear for the election commission.
Yes.
May I make one submission with the leave of your lordship's view? Item 43, a similar direction is issued in respect of DCC Bank Kupola, where earlier occasion your lordship directed the government to file an affidavit. What steps have been taken to implement the order of the learned single judge? Then matter came up earlier occasion, want of time alone is not reached. May I request your lordship to have that matter along with this also, madam. It could be heard together.
Both are different. This matter.
Both are different.
This is Mysore and that is different.
Polar. Identical direction was issued. Both are DCC Bank. In my case, may not pursuant to the order of the learned single judge, 14 notification was issued. The election is intended to be completed on or before 28th of September. No steps have been taken thereafter, except issuing the Rule 14 notification. Therefore, your lordships are looking into the same.
What is the Rule 14 notification?
Rule 14 notification issued by the election officer.
I'm not looking into it.
Indicating the date of election to be completed by the authorities. Pursuant reference to the order passed by the learned single judge only.
Now they have started this step.
No, no
in
steps
effect-
have been taken, except that notification, according to my instruction, no progress at all. Therefore, your lordship directed.
Your Lordship, we complete this matter, then we'll see that. I'll look into it by,
wait
I'll look into it by then.
It could also be taken up along with that. It could be hard, I know.
After this, not along with this, after this. With me, senior.
Your lordship may kindly have the contempt petition, my lord, for the purpose of reference.
The meanwhile, I have made an application for extension of time for the reason that there is a statutory appeal and there is a statutory interim order. These steps are being taken to get the stay order vacated. And the election process had commenced and it has been intervened because of the interim order that was passed in the statutory appeal. So I made this application for extension of the period only to enable the interim order to be vacated and immediately thereafter.
So extension for holding the election.
Yes, my lord.
Yeah, time to hold the election.
And we have given an affidavit, my
Your-
lord, as
Your
I
Lordship.
pointed out, the time schedule in my compliance affidavit. I've given a time schedule, my lords.
In the contempt petition, my lord.
Your Lordship,
Now, first we'll see the contempt order.
Please,
Second, we'll see the application filed by for extension.
Election Commission.
please, madam.
And thirdly, we'll see the timetable.
Please. Kindly see annexure,
Order we'll see, yes.
annexure A,
I-
page 19,
I think
in
the
the contempt. petition.
Extension application may be heard first. Because if,
No, let us see in what context it is filed, so that we are seeing.
very well, I leave it.
Page 19, annexure A, madam,
Page 9.
in the contempt
Contempt.
petition. Brief facts prior to this order was, my lord. Election in respect of this DCC Bank Mysore was announced. Midway, it was cancelled. We approached in the writ petition, seeking a direction that election should continue from the stage from where it was stopped. But the learned single judge, though allowed our writ petition, he said it would be a fresh election to be conducted within four months. 4 months. Then we preferred appeal. Annexure A is the order in the writ appeal, my lord. Order dated 2/1/2024. Kindly go to page 68. Or rather 67, my lord, 67.
Around 68 only, yes. 61 you want, 67, yes.
67.
Yes.
As to the desirability of conduct at the bottom. As to the desirability of conducting the elections to the board of DCC Bank expeditiously. All the above being said, we are of the considered view that right to form a cooperative society itself being a fundamental right, as already discussed above, the holding of elections to the board of DCC Bank cannot be deferred or delayed indefinitely, as has deplorably happened in the cases at hand. Now that the CEA and the jurisdictional EOs are taking steps on a war footing, the process of election should be accomplished in true letter and spirit of the impugned judgment. At the same time, we permit the marginal relaxation qua the timelines prescribed by the extant rules. And also the period fixed by the learned single judge in his order dated so-and-so, keeping in view the apparent difficulties authorities may counter in the exercise. Since this concession is being made in peculiar circumstance of the case, no one need to have an apprehension that this view would be having any precedential value for being tapped in other cases. So in relaxation of rules, in the above circumstance, with the above observations, these appeals are disposed of with following direction. The subject elections shall be conducted preferably in an outer limit of 8 weeks. And for that, all stakeholders, including the government, shall take
facilitative steps. The jurisdictional administrator shall take over the functions of the board. All that has happened, the administrator has taken over. This order is passed on 2/1/24, granting 8 weeks time in relaxation of the conditions of the rules with regard to certain procedure. On 2/1/24, though this order is passed, till this date, not even a publication of voter list has taken place. No steps were taken. First, they said this could not be complied because of the parliament election. There was a government order postponing the election, which my learned friend has produced along with the extension application, my lord, in the writ appeal. That notification specifically says all elections are postponed, but in respect of election proceedings, if the election process has already started or is to be started as per the order of the competent court, then this order should be brought to the notice of competent court and proceed as per the order of the court. They did not make any application saying, in view of this order, we will not be able to do it. Therefore, we seek either a direction or some clarification or anything. From 2/1/24, every effort is made not to hold election. In respect of this very writ appeal, in respect of Davangere DCC Bank, same order of 8 weeks was granted. Government did not find this parliament election notification or any other impediment. They went on to hold the election and elections were held. For this Chamarajnagar Bank, where the opposite party or the persons in control of the bank at that time elected representatives are from a different political party than the one which is in office. It is that which has made. Why I am saying this is, in case something seriously wrong with the bank, there is a provision for superseding. Even in case of superseding, they cannot do it without consultation of the Reserve Bank of India. And even if Reserve Bank of India permits it, it cannot go on for more than 6 months. Now, in our case, it's almost now 10 months that there is an administrator appointed without holding the election. The timetable now given by the other side, the timetable is, they propose to publish the voter list, etc. in November and then hold the election on 18th January 2025.
No, 3/1. Serial number 13.
All right, I stand corrected, my lord. 3/1/2025. 8 weeks is something which they are, the way they have conducted themselves, they are mocking at the order in doing this, seeking time, saying we have started in 16/1/2024 and election will be held on 3/1/2025. They want 12 months to be this. With regard to extension sought on the grounds that we have now made preparation, etc., is something I would say none of them are sincere to hold the election. A direct, deliberate contempt is being committed for the purpose of this. Now, my lord, the election authority says they cannot hold election because the Registrar of Cooperative Society has passed some stay order. I would ask myself, if there is a direction by the High Court
that it should be done within 8 weeks. And someone, assistant registrar or someone passes an order, can it be said by an election authority that because of the registrar's order, I will not be able to comply with the direction issued by the court? Neither registrar nor anybody else can pass any order, nor any order passed by such person can be taken note of to say we will not be able to implement the order of the High Court. And registrar is a party to the writ appeal, to the contempt.
So where is the order of register staying the election?
That is the application, in the application given by, he stays a bylaw so that election cannot be held. That is given by the Election Commission. Yes, my lord, it is 18.9.
18.9.
Yes, my lord.
Page 37.
The page 48.
Document number 7.
Document number 7, page 48. It is in the writ appeal. In the application filed by election commission, election authority rather.
Page?
Page 48. It is given in the application dated 8/9/2024, 18/9/2024. Application number in the writ appeal. Number ಕೊಟ್ಟಿದಾರನ A number.
Maybe IA 3 of 24.
That is IA number 3 of
2024.
In the writ appeal, IA number 3 of 2024 in the writ appeal.
Filed on 19/9. Filed on 19 September.
Now this interim order of the 1 second. Interim order of the registrar is dated 27.
Yes, madam. 48. Kindly see page 49.
27/6/24.
Please.
The order.
Some,
Order of-
27/6/24, after the High Court order, some societies said to have filed an application that one of the amendment of bylaw order should be
cancelled. He says there is an application for condonation of delay of 2 years, 3 months. Yes, I deem it proper to condone the delay. Then he says,
So that order is on
27th June 2024,
Division bench of this court passed order on 2nd January.
2nd January,
And in that order, it was provided that within
8 weeks. Registrar was a party to that order.
8 weeks for when?
3rd March 2020.
March. So 3 months was a vacuum on your part. You were never interested in holding the election.
We wanted it to be held.
You did not do anything for 3 months. And then thereafter, this registrar orders came.
No. We filed the contempt petition.
When? When contempt petition?
6th February 24, pointing out they are not taking any steps to comply within 8 weeks. They were to do certain things within 8 weeks so as to hold the election. They were not taking any steps.
All of stand corrected. Then what happened?
Then
Yes.
they are merrily continuing.
So they are saying that irrespective of issuance of election program now, there is a contempt. That is the submission.
Now, the reason why this application for extension has been made is for the reason that even as the process of election was being contemplated, and it is the election officer who has to issue the calendar of events, it was about to be issued. It is at that point of time, elections to the parliament were declared. And all elections to the cooperative societies stood postponed by an order of the government.
You have produced.
Yes, that is placed before the court.
So your application is which application?
Yeah, along with my application, I have placed it before. Page 12. Page 12, document number 1. Page 12, document 1, may kindly be perused.
Your paging in this high court, I am never able to come to the tune of, yes, not able to match with your concept of paging, yes.
Shall I file a separate paper book
No,
giving?
not. This one, Proceedings of Karnataka government.
Yeah.
Yes, what is
Proceed.
that?
Please, it's a short order, kindly permit me to read that.
Yes.
Now, before this order came to be passed, on 9/2, we had made an application before this honorable court seeking extension of time.
On
9/2.
9/2.
9/2. Earlier application was made seeking extension of time.
So that application was made within 8 weeks. That
Yes, yes, 9 February, it was made. And I don't know whether there is a written order when the the matter came up for consideration before the court. And in the interim, what happened is on 21/3, the government or the elections to the parliament were declared. And the code of conduct had come into force on 16/3/2024. On 16/3/2024, the code of conduct in view of the parliamentary elections was enforced. And on 21/3, government itself directed postponement of all elections to cooperative society. By amending the Cooperative Societies Act in exercise of the power under the removal of difficulty clause.
the postponement of cooperative election by amendment.
But under section 121 of the Act, they have the power to exempt application of any provision of the Cooperative Societies Act.
So
Yes, yeah.
postponement was by amendment.
By this notification. It
Not an amendment, there's a
it is
provision.
not an amendment actually.
Section 121.
Yeah, section 121 is removal of difficulties clause. So in that view of the matter, the entire election machinery was
What is the date of notification?
21/3.
21/3.
Yes. And there was a specific direction. Wherever the election process has already started or is to be started, as per the orders of a competent court, this order should be brought to the notice of the competent court, and the process should be initiated as directed by the court. It is in the light of that, the subsequent application for amendment came to be made.
This notification is read which page?
21/3.
Page,
Page 12.
same notice.
Yeah.
Well,
A relevant part is at page 13. May just, it's a short order, I am permitted to read. Yeah. May I read the whole order from page 12. The preamble is very important. Yeah. In the order of reference at serial number 1, it was ordered to postpone the elections of the cooperative society and banks where the board of cooperative societies is about to expire, and to extend the term of the board and the office bearers. As the code of conduct was not in force on 13/3/2024, the order read in 1 was withdrawn as per the order at reference number 2 above. In the notification read at serial number 3, the Central Election Commission has issued a notification for the Lok Sabha elections 2024, and the election code of conduct will be enforced from 16/3/2024 to 6/6/2024. In the letter of the Cooperative Election Authority, that is what we had written, at reference 4, the election code of conduct has been issued by the Central Election Commission. Elections of more than 1,200 cooperative societies, including federal, secondary, primary cooperative banks and societies, so are the cooperative societies in the state, are to be held from March 2024 to June 2024, and required the number of staff are needed for the said elections. The Cooperative Election Authority has informed that it will be difficult to conduct the elections of the cooperative societies in a free and transparent manner in the wake of the general Lok Sabha elections, as regional commissioners, deputy commissioners, officers and staff of all the government departments, including the cooperative department and the police department, are assigned to the Lok Sabha election duties. In this background, there is a need to postpone the elections of the board of the cooperative societies where the tenure of the board expires in the period from March 2024 to 6/6/2024. Administrative officers are required to be appointed to the boards of cooperative societies or banks whose term of office is about to expire. In accordance with the provisions of Section 121 of the Cooperative Societies Act 1959, the state government, as a special content, will have to postpone the elections due to about 1,200 different categories of cooperative societies during the period March 2024 to 6/6/2024 on account of general Lok Sabha elections. However, considering this as a special situation, as there is shortage of staff to appoint the administrative officers in view of the departmental officers or staff being assigned to election duty, postpone the elections of the Board of Cooperative Societies, whose terms of office will expire from March 2024 to 6/6/2024. Considering that it is necessary to continue the tenure of the existing board and the office bearers, it is ordered as follows. Government Order Number so-and-so dated 21/3/2024. In the light of
Continue tomorrow or when? Whenever you want, we'll continue.
any day convenient.
Let
Any day convenient.
Party 3 may also be taken up along with item 43.
43 will be posted along with. So when shall we?
I have to file objection in that matter, my lord, either Wednesday or Thursday next week. 45 Wednesday or Thursday next week.
Next week,
Next week.
Thursday.
ಅವರೇ ಹೇಳಿದ್ರು continue.
Sixth, seventh can be taken.
Please,
Seventh at
please let this also come.
both 3 and 14.
Please, please.
I request him not once.
Send for 3 and 14.
I request him not.
This matter,
Seventh it is suggested.
Seven.
The mayor request him not. There are 7 matters of me, Lord, where industries have been closed by the pollution control board. Not at reach him, Lord. May request a short date, and one more request, Lord, with notice to other respondents may be dispensed because they are not necessary.
They are not.
Necessary partners. They are only consequential, Lord. Therefore, this may be. Except in the pollution control, they are served. Other respondents not necessary.
You're deleting.
Yes, I am taken, submission may be noted, Lord, I am not pressing. Notice may be dispensed for.
Deleting those parties.
Yes, other party, except pollution control.
Learned
Other
educated for 3.
23.
Mr. So and Mrs. So and
Number
so
and
and
give.
so.
There are 7 industries.
6 permission delete all the respondents.
Yes, other
Except
respondents.
Karnataka Pollution Control Board.
Yes.
Permission is granted to delete rest of the parties except Karnataka Pollution Control Board at the cost and consequences of the petition.
Short date and all.
Which
213.
all right, 2:30.
Any short.
No date.
Other matters will be taken up tomorrow, my lord, which have not reached
It will be date will be given.
date, my lord. Then interim orders may kindly be
Dates.
Lord, serial number 118. My lord, I had moved this matter. KIDB acquisition, final notification is issued after 10 years of preliminary. I was enjoying the stay order during the writ petition, my lord. There is a threat of dispossession now. In fact, I had specifically moved this matter. There is an office objection also that I have not produced the entire translation. I have produced the relevant pages of the translation, my lord. That may be dispensed with and it may be taken up for admission, my lord. There is some urgency because the KIDB has come to take over possession, my lord. That's the difficulty.
Take up. Sixth will take.
6th, my lord. My lord, there is an office objection regarding, my lord, I have produced the translation of relevant pages of the notification, my lord. That may be.
It is translation of entire notice.
Please.
with my lord's.
For the
kind
next state, the office of will be complied.
My lord's kind
Then only the petition, then only the matters will be placed.
kind permission, my lord. Serial number 117, my lord. The college, the Samram Medical College, my lord, which has imparted education to the 5th and 6th semester students, my lord. But the students had deposited the amount of their fees before this honorable court, my lord. And we had challenged that order
that it should not be disbursed to the students and should be considered that it should be given to the college, my lord. And this honorable court passed an order not to withdraw the said amount, my lord. But in the meantime, they have, the office has paid that amount by electronic transfer. This is what the memo is filed today, my lord, saying that it has been 3 crores have been transferred, my lord, to the students. My lord. So this matter may kindly be taken up at the earliest, my lord, because they have stated also that even though the interim order is operating, my lord, still we will be able to deposit the whole amount, my lord. Therefore, this is a matter which requires your lordship's consideration. May kindly be taken up at the earliest, my lord. Tomorrow, day after, or
Which date do you want?
I appear for the respondents.
yes.
I appear for the respondent students.
When do you?
But any day subject to your lordship's convenience.
Choose any date in the week.
5th, my lord. 5th of November, my lord. At 2:30 or because this is urgent because the amount has to be redeposited if your lordship.
That of
directs.
course, we'll submit my lords on the main matter itself.
We'll see on that.
Very
Yes, please, my lords.
Your lordships, serial number 23, your lordships. That the interim order has to be extended to your lordship.
In all matters, wherever the interim orders are operating, they'll be.
And it may be posted on 3rd week of November, your lordships.
In this matter also, my lord. Please. 117.
Serial number 23.
30.